They may be working in some other
Even
departments.
group C, group D, whatever it may be, maybe
Some other departments, not
department.
even in
Your lordship is absolutely correct. Not only the institution, but even the department, central government
Yes.
school, etc., everywhere.
There no question of extension because
No
they
question of extension.
till
No
the
question of
age of
just
retirement.
come to next. Since we couldn't do it, contempt application was filed.
What you could not do?
We couldn't do within the 3 months.
What you could not do?
Their applications were processed.
You could not process the application.
Application.
All right.
They filed an application for contempt.
Yes.
That the Supreme Court order was to do it within 3 months, but they have not done it. The blame was shifted to us.
All was pre-2016 recruitees.
Yes.
26.
Correct.
2016.
This batch, this paragraph 47 batch categories, most of them have filed the applications for contempt. That time, contempt application notice was already. Then we got time up to 10th November.
To process their application. Yes.
And this order was passed in 19th September.
All right.
10th November. By 19th September to 10th November, we have completed that job. Can you come to his order of transfer? Can you come to the 55?
Which matter? 2514.
55.
Yes.
Can you see the order dated 15th October 2025?
Sriporna Chaudhuri. Dated 15th October 25. Yes.
Order was passed.
Yes.
Under PST.
And বিয়ের ওখানেই কনফিউশন যদি পার্টিসিপেট করে করবে সেটা বিয়ের আপনার তো বিয়ে এখানে আবার ফেরত দিতে পারে আমাদেরকে জজ করেছিল যতদিন 17th এপ্রিল এই অর্ডারটা ইলেকশন প্রসিডিং যতদিন কমপ্লিট না হবে ততদিন আমরা চালিয়ে যেতে পারি তো আমরা চালিয়ে যাচ্ছি as per that order
Within 30 days from the date of receipt. That means her application has been processed. Then what remains?
What is everything has been done. Now what is saying? His case is 17th April, the order was passed. For the rest of the person, that was given up to 31st December. Now, after 31st December, it was extended up to 31st August, subject to the condition that all selection process should be completed. Everything should be completed.
No, sorry. Please repeat it, this portion. I couldn't follow.
On 17th April, the Supreme Court passed the order that up to 31st December, you should complete the selection process.
That is for the fresh candidates that you will appoint.
Fresh and untainted.
Fresh selection process.
Fresh selection process.
Right.
Correct. Fresh selection process. Up to 31st December.
Yes.
You must do it. Condition. The untainted teachers, apart from paragraph 47, whose services were terminated, they have continued up to 31st December.
Yes.
Thereafter, my lord, we have filed an application. In that application, court has directed that all right, we are extending up to 31st August.
That is the fresh selection process.
Correct.
But then that has nothing to do with this appointment letter.
Nothing to do. My lord is absolutely correct, my lord. Right, my lord. There is nothing to do.
Then where is the question of extension come?
Mr. There is no scope. My lord, if I allow to continue even, then I am committing again contempt of the order of the Supreme Court.
Whether you are allowing to continue or not, that is only in respect of the candidates in the fresh selection process, and that has got nothing to do with the order of repatriation.
I am saying, if I allow the persons whose names have been blocked in paragraph 47 to continue up to 31st August, then I am again committing contempt of the order of 6th April 2025. That's how I want to say that. That is a completely, even if the state issue, let me tell you also very candid. The order which is being relied upon by them, that was by the statement, that was contrary to the Supreme Court's order. Therefore, they have kept in abeyance.
But one thing you are sure that the repatriated candidates fall in a separate set and the fresh selection process is different. They are two different things.
Completely.
That is his understanding.
Statement has submission has been made that amongst these persons, some candidate made the application.
That is different.
Different, but just 1 minute. First, the details are not there. Secondly, now panel has been published. He couldn't say that yes, my name is in this panel. Those names, whose names are there in the panel, and those who are untainted, even from tomorrow, the counseling is going to start. 500 persons have been called tomorrow. The moment counseling will be over tomorrow, we'll give the documents to the board. Board will make their appointment. Verifications will be done. State government may give the appointment within 1 month. That doesn't mean the persons who are there untainted, purely untainted, not even paragraph 47, he will continue. He has to leave. He has to leave. There was 31st December, 31st August, the outer limit for the general 2025 selected candidates are concerned. And this block, this paragraph 47, is out of everything. Kindly appreciate. Yes. 6th April, from 7th April, nobody's service was there. Excepting these categories. Paragraph 47. Excepting this category, because their applications have to be directed to be processed within the 3 months. The 6th to 17th, only 300 persons were working within, including my learning friend's time. He enjoyed the benefit of, kindly appreciate this, he enjoyed the benefit from 7th to 17th of that order.
Milord, may I, Milord, because if created a cloud of confusion, Milord. 47, Milord, if your Lordship says, Milord, if your Lordship, Milord, makes it a two different and distinct class, Milord, to that, Milord, I have, Milord, a submission to make. Milord, your Lordship is convinced to the point, to the extent, Milord, that before 2016, Milord, we are engaged, Milord, in different department of the state government. After 2016, Milord, selection process is over. We got the appointment letters. We have been discharging our duties. 2016, Milord, came to an end on 3rd April 2025. The paragraph 47 does not, Milord, distinguish. It gives a window to us to make an application for a situation. The Supreme Court took note of the fact that since we had discharged our duties prior to 2016 selection, this avenue was created for us. The order, Milord, of the Supreme Court, with deepest respect and with humility, I submit, Milord, it does not make a room for, Milord, making a perception or to make an inroad to come to a conclusion that this order stands applicable after the extension was made till 31st December 2025. It only applies to those candidates, Milord, of the 2025 selection process and not for us. If that is the interpretation of the judgment, because further extension when was made, the Supreme Court did not clarify, none of the parties, Milord, not the government, that because the government was quite conscious about the applications or the order of the Supreme Court. Paragraph 47, it creates an additional avenue for us. It does not make a distinct class that this order of extension which was granted
what you'll want
reversion, Milord,
you'll want to
today, Milord, if your Lordship makes this interpretation, then, Milord, I will be jobless on and from this day. Jobless means I cannot, because government will, because my repatriation will be Milord, taken note of care of after, Milord, August 2026.
Why?
I do not know. There is no assurance. Because
there is an order of repatriation in his matter. Or
where is that in our matter?
There is an order where you have been repatriated.
Repatriation, Milord, is a matter that is yet to be processed. My learned esteemed senior friend has said they may have made application. it is under process. And he said
The applications have been processed.
process. But what is the outcome? I do not know. I said, Millard, this order 29/12/2025, the order, and 30th December 2025. Why the government has withdrawn 2029/5? Is it a case of the government? Is it reflected from the order that we have committed a mistake, or it is an executive inroad?
Don't go to that order. You tell me what you want.
I want that this
But 1 minute. You are-
extension of repatriation. Extension of repatriation.
You want to take a chance in the fresh recruitment process also.
I have already taken a chance.
You have taken a
Yes,
chance.
I do. Yes.
You want your previous service to continue?
No, I said, Millard, that is not the correct interpretation. I said, Millard, with humility, that the repatriation.
Have you been
application-
repatriated?
No,
Where is your application for repatriation?
No, he has been repatriated.
Please show. Where is your application? That is the next matter. Wait. Let us come to item 4. Where is your application for repatriation?
153.
There are how many candidates over here? Writ petition has been filed by 46 candidates.
Yes.
Can you show me all 46 candidates making application for repatriation?
Millard, it starts from 153. Rupa Banerjee, the petitioner, her application, 22nd December, prayer for extension of rejoining date. I respectfully submit this application.
The order was passed in April and you file application in December?
That is why extension, prayer for extension of joining period. I said,
You see extension of joining. You can go on filing applications at any point of time.
Millard, that is Millard prior to the issuance of Millard 29 December 2025.
29
137
got nothing.
before that. 137.
Yes, please show.
137. Excellent. 29th October 2025. Rupa Banerjee, Chairman, School Council. I have given in compliance with the order of the Honorable Supreme Court of India, such and such, the undersigned request him to rejoin the assistant teacher of the Binodini Girls High School.
This is on 29th
October 2020.
Then again 22.
October. Did you join?
No, I could not.
I could not.
Why?
In terms of 17
17th April order kindly cease.
order of the Honorable
Supreme Court said
I
that
have to
Vijay,
stay- I have
that
to stay
it is subsequent and it shall be prompted to pass this order in respect of the assistant teachers not found to be tainted is that students undergoing study presently should not suffer on account of lack of teachers and lapses and failures which have resulted in the order passed by this court. That is Millard, page 134.
And thereafter,
Supreme Court said,
then after 151, only-
then
Page
151.
130, please, sir. Page 137, there is an order of the Primary School Council where you have been directed
to region.
to join as assistant teacher of a primary.
I did not join.
Why did-
Answer is because Millard, I said my understanding of the order of the Supreme Court, page 134,
Dated-
kindly sees dated Millard,
17th April
page 17th April.
2020.
What does it mean?
Kindly sees the order that it says that this order prompted us to pass this order of the assistant teacher not found to be
Which
tainted.
order are you reading?
17th April 2025, page 134 of your Lordship's brief.
134.
That is my understanding of the order.
1 minute.
151 to that.
Then 151.
1 minute. 17.
এই 4 নম্বরটা দিন তো।
17th April, yes. Yes.
Yes, 17th April. Let me read the order, Millard. We are inclined to accept the prayer made in the present application insofar as it relates to assistant teacher for classes 9 and 10, classes 11 and 12, not found to be tainted, subject to the following conditions. An advertisement for fresh recruitment to the aforesaid shall be published before such and such. The examination and the entire recruitment process shall be completed by 31st December 2025. The state government, the applicant, West Bengal Board of Secondary Education, and the West Bengal Central School Service Commission shall file their respective affidavits by 31st May 2025, enclosing therewith a copy of the advertisement for the fresh recruitment as well as a schedule therefore, so as to ensure completion of the recruitment process by 31st December 2025. In case the advertisement is not published by 31st May 2025 and the affidavits are not filed by that date, appropriate orders will be passed by this court, including imposition of cost and vacating of the present order. We clarify that this order shall not be read as conferring any special right or advantage on the aforesaid teacher insofar as the fresh recruitment process is concerned. We are not inclined to accept the prayer of the present application insofar as non-teaching post in Group C and D are concerned.
You are not
No.
teaching, so do not read that.
Yes. Then Millard, Then Millard, it says Millard, no, ওটা উল্টা লিখে নাও 134 পড়তে দি পুরোটা in this highly and secondary which has prompted us to pass this order in respect of assistant teachers not found to be tainted we are coming under this category is that students undergoing study presently should not suffer on account of lack of teachers and lapses and failures which have resulted in the order passed by this court. Then Millard 151 page. It is a bona fide understanding of the order of the Honorable Apex Court. These miscellaneous applications are ordered granting extension of time for completion of the selection process concerning assistant teacher for classes 9 and 10 on the one hand and for classes 11 12 on the other till 31st August 2026 or in the event the process is completed prior to that till that date whichever is earlier completion of the selection process would mean culmination in the issuance of appointment letters. We make it clear that the untainted teachers already appointed who were permitted to continue up to 31st December, we are coming under this category, shall continue to hold their posts. It is shall, not may, till such date of completion of the process. That is why, under a bona fide understanding of this 29 December 25, government has made an elaborate discussion and passed this order. 31st December, Millard, suddenly change and one line cryptic order, matters ends. So, Millard, today, if your Lordship says, why did you not join? Millard, I am saying, Millard, with humility, that Supreme Court page 47, 133 and 34, read with 151, it is, Millard, a formal extension. Supreme Court has, Millard, expressed his anxiety that dearth of teacher, Millard, would cause prejudice to the interest of the student. If that is the understanding, Millard, that is bona fide. Commission is not prejudiced by my such bona fide understanding. The government is also, Millard, quite aware of the fact and the ground reality had issued this order. Kindly 29 December, elaborate discussion and, Millard, very recent discussion, Millard, the Honorable, the page 162, the Honorable Supreme Court in India.
One thing.
Sorry.
Are you agreeable to revert to this page 137 that you have shown?
You are agreeable? I লিখিত নিয়ে নেব আজকাল দিনকাল ভালো না লিখিত নিয়ে নেব
Instruction.
Millard, I will file a written instruction that if you are agreeable then Millard I should be allowed to repatriate. That is the mind of your Lordship. Because Millard,
This
commission
is in October 25 with immediate effect you were supposed to join your previous posting.
I cannot travel beyond the records. I said this is my understanding. And Supreme Court's order 133, 134 clearly Millard expressed its agony and anxiety, students' interest. I did not join because I relied on this.
Student will take care of it.
Millard, he is very generous, Millard, and he is a source of fountain of compassion. If he says and if he allows, Millard, that I may join, I do not wish to.
Who is he to join? Because it's a council.
Because he is saying something, Millard.
It is
No, he is saying that I will take care of.
letter.
He said that we will take care of the situation.
Go to him and get
No,
order done.
he said so.
What he says is not the matter to be looked into for deciding a matter.
I said, Millard,
Page
primary school council
137.
asked me to join. I did not join. Your Lordship's query is simple.
Yes.
Yes, I cannot play
Right.
tricks with your Lordship. I
Exactly.
said, Millard, I did not join. Why I did not join? I sought to explain by interpreting the order 133, 134, read with 151. I did not join. If your Lordship says, are you willing to join now? Give me one day time. I will file a letter. I will join.
Show me the this appointment letters of repatriation of the others also.
All
All are there.
all are there.
What is the date?
133, the Bata.
37 you've showed.
Yes.
138 is my lord petitioner number 2, Rafia Khatun. 139 is my lord petition number 3, Sabgupta Naj. 140 is my lord Rokshinath Parveen. That is petitioner number 4. Then 145 is Mohammad Asif. That is petition number 5, my lord. I have annexed in that format only, my lord. Then Mohammad Nizamuddin Khan is petition number 6. That is 142.
All 29th of October 2025.
Yes, my lord.
You all deliberately did not join.
Millard, I said.
Took a calculated chance to sit in the examination. Now when you are unsuccessful, now you want to repatriate and you want to continue with your service.
Primary council, kindly see the letter 162. Primary school said, primary council said, director of school primary branch, they extended, Millard, 162. They did not take any steps.
They only extend,
They also extended,
allow extension of joining a period.
joining a period.
163.
They also page 163.
Nothing calculated. It's the government.
It was a government
No,
notification.
This is 29, this is there, this is under challenge.
No,
That is different.
29, no, 30th is under challenge. 29th is not under challenge. 29 grants extension.
We want 20.
So, Milord, between October 2025 to 2025, December, the primary school council was aware of this fact. Milord, that is the,
You cannot come out of the explanation. Your repatriation order is of October. The commissioner's order is of December. What were you doing for
no,
these 2
Milord,
months?
these 2
This is
months.
your
No,
explanation.
this is my explanation because I said the Supreme Court said so.
Yes,
If your lordship permits us,
followed it.
Milord, if your lordship says that I can join tomorrow, Milord, I can join. Permit me to join tomorrow, Milord. Permit me to join tomorrow. Supreme Court has taken care of. Milord, your lordship has seen, Milord, in many matters that we are not at fault. We are not at fault. It is the fault within our stars, Milord, that we are undergoing through this system. I want to go back. Give me 2 months, Milord. All failures in life cannot be treated as sin.
I'm invigilator in now. I'm an invigilator.
It is a failure. I, Milord, bow down to your lordship that I did not join. I am an invigilator. I am discharging a duties, Milord. Supreme Court 133, 134 categorically states that students' interest. If I interpreted, Milord, that I did not join, Milord, I was not sitting idle. I joined duty. I did regularly discharging my duties, Milord, as a teacher. I am invigilator. Madhyamik and higher secondary, I am renewing my service, Milord. We are all teachers, Milord.
Now the council is not a party in the writ petition. The one
Primary
that
branch is the party.
is the party.
Primary party. Kindly direct the primary board, Milord.
Number 2. Director of School Education.
Director of Primary School Education, respondent number 2.
No, that is the director of school education.
Yes.
All right, let me hear from the state. Item number 4, who's for the state? Yes.
4 and 5 are both apart.
There is no argument that the court requires. There is already an order of repatriation. Can the date be extended so that they can go back? This is the only query
Yes,
of the court,
yes, Lord.
nothing more. Because they have been engaged as invigilators and supervisors and the examination Madhyamik and higher secondary is there. They want to repatriate. What is to be done? What is to be done?
Manoj, can I? Lord, after the disposal of the contempt application, the order which I have read to your lordship, there is no scope by anyone to extend time.
Which time?
Yes, after 15th October, that
No, 29th of October is the letter of repatriation.
the order contrary to the Supreme Court's order. That is the reason it has been kept in abeyance on the list.
No, sir. 29th of October is not in abeyance.
29th October is the order for
Repatriation.
repatriation.
Yes.
19th October, the content matter was taken up by the Supreme Court.
That is a different matter.
But these petitioners, this category of these teachers, they have filed the application before the Supreme Court.
You are confusing now.
I am not confusing. Sorry, if I am confused, I am very sorry.
I am confused. You are clear.
No, I am just exactly I am saying.
Yes.
Paragraph 47 is clear that 3 months, within the 3 months, they have order
Is to be processed.
processed.
Now it has been processed.
Just since the gap is there, I am making time.
Ah.
Within 3 months, we couldn't do it.
Yes.
Correct? Naturally, Milord, a batch of contempt petitions were filed against us
Yes.
by this category of person.
Yes.
This batch of category of person filed the contempt application that, see, you have directed that within 3 months it has to be done. Then it has not yet been done. Then we appeared and asked for time for compliance of the Supreme Court.
That is for conclusion of the fresh recruitment process.
That is for the contempt. That is the order, madam, kindly. Kindly see, take this.
No, give me the date. The orders are. Then I need printouts. I will not see soft copies.
October 2025 in contempt application.
Is the order there anywhere?
আপনি পড়ে দিন না
27th of October is the hard copy there.
আরে আরে পড়ে দিন
Read out.
পড়ুন
27th October 2020. The petition was called for hearing today. Upon any counsel, the court made the following. Learned counseling appearing from the state of West Bengal states that the candidate sent back to their former post in terms of the directions of the court in paragraph 47 of the judgment dated of the by 10th November 2025.
All right.
And within 10th November 2025, the orders of repatriation were issued.
কি করব
10th of November 2025. Yes.
Your lordships have seen that the repatriation orders all are
Issued prior to that.
20.
Yes.
Now 10th November 2025, 17th November, the matter has been disposed of. Since the order has been complied with.
Hmm.
That is not learned counsel of petitioner states that the petitioners have now been permitted to join duty pursuant to the directions of this court in paragraph 47 of the judgment in this transfer. And we are further informed by the learned senior counsel appearing for the state of West Bengal that the seniority and other entitlements of these persons would be preserved, including their eligibility for grant of increments as directed by this court.
All right.
Therefore,
And the next paragraph, in the event the petitioners have any other grievance,
once or issue,
they
they necessarily have to seek redressal thereof by way of independent proceedings in accordance with law.
before your lordship
Oh,
now,
question therefore, is there another issue?
হ্যাঁ
Is the new issue or the old issue? If the old issue, chapter is over.
no
If the new issue, then the chapter is. Now here, the order was passed, repatriation orders was passed in October.
yes.
All
And
right,
the teachers were supposed to join immediately.
immediately, they
Right.
didn't join. They have not joined.
Yes, they have not joined because they are teachers teaching in classes where examinations are being held.
yes
No examinations were held. No examinations were held. In the
What
month
were-
of-
what-
In the month of October, which examinations have been held?
It
Nothing.
is for you.
Exactly they are saying. This is all from the bar. No examination.
All right, you do not have anything to say now. The state government or the council, the primary education department, if they choose to extend time for repatriation, you do not have an issue.
No, no,
You do not have an issue.
I don't have any issue.
Commission, because your part is over.
If your lordship take me that as a officer of the court, I am just trying to assist.
Yes, I have followed it. Now the only thing is to be done if the state government primary department says that yes, they can be repatriated, they can be repatriated. What is the stand of the state?
I don't take instruction because some problem is there. Advocate General, I talked about the Advocate General. Also, both the class 4 and 5 argue better, don't argue the better. The repatriate of order Advocate General will argue the better. A clear picture will become.
What, you are not agreeable to allow them to repatriate?
The question is, Malad, they have made a choice. Malad, when they chose not to join, Malad, I have to. Malad,
I have understood it.
Yes.
They are job losers,
Yes.
untainted candidates, permitted to be repatriated because they are still in school and they are being given duties of
মাধ্যমিক and high
all
school
this. Right now,
নো মাধ্যমিক
if
Malad, yes.
if
এখন তো-
showing some mercy, at least they can be repatriated.
I'm extremely grateful,
Nothing
madam.
more.
What has fallen from your
I'm extremely
Nothing more. Yes, come back.
he wants to say
No, my lord, one thing before your lordship, before your lordship passes.
Sir, one minute, sir. Yes, sir. West Bengal primary court. The main of head of council. They have not been made part. Kindly make them part.
মাইতে পার্টি আছে আমারটাতে পার্টি আছে
হ্যাঁ
Certainly not. You all have got conflicting stand. The primary board and the commission will have
প্রাইমারি কোর্ট পার্টি আছে
the respondent number 2. Please check up. Directorate of
Yes,
State
primary
Education,
court-
Government of West Bengal primary branch is already a party. Let a stand be taken.
প্রাইমারি ব্রাঞ্চ পার্টি আছে
Do not mix up because you all have conflicting
Malad,
interests.
before your lordship, Malad passes.
I do not know whether everybody has been issued the letter of repatriation or not.
Very well, very well. But kindly seize once page number, because I expected my learned friend for the state at least to be fair to your lordship. Kindly seize item number 5 once. I'll take your lordship 30 seconds time.
The state has not made any submissions, sir, today.
My lord, he said that they have already chosen. They have made the choice. Now they cannot do anything. Lordship, kindly seize page number item number 5 once.
Yes.
Only once. Yes, of course, of
All
course.
right, all right.
They could have said this
I-
before your lordship.
You listen what is submission so that you can revert with proper instruction.
But,
Yes.
Lordship has seen already page number 50. Lordship has already seen, my lord, page number 55.
Next Wednesday? All right. Yes.
So, my lord, page,
Wait 1 minute.
so my lord, lordship has seen my lord, page number 55 in item number 5. My lord, lordship has seen this is the letter in which we are supposed to join in 30 days. They said that since we did not, so I have already chosen not to join. Kindly, my lord, turns, lordship has seen it is Sriporna Chaudhary. So, my lord, kindly turns page number 61, 60. So then your lordship sees this is the order of 13th of November 2025. Then my lord kindly sees what happens here. The Sriporna Chaudhary.
Extended till 31st of December. Yes.
So now,
Even then you did not join.
I tell you lordship, in this meantime, I made the prayer for extension.
Further extension.
Yes. So that,
How many
I tell you lordship, I'm sorry,
selective
Madam.
chances will you take?
I'm just trying to take your lordship to that. Before 31st of December, I tried to, my lord, take an chance for extension of the time. Because as my lord senior my lord already pointed out your lordship that this was a window to those persons, those category of persons. I wanted this window my lord to remain open.
Along.
At least my lord till the selection process is completed. So
Why does the lordship understand everything?
and then my lord says this is why before 31st December they have extended the time, 29th of December.
The petitioners claim to be the untainted candidates of the 2016 recruitment process. Stop. Prior to joining service in terms of the 2016 recruitment process, the petitioners claim to be engaged with other departments and autonomous bodies of the state. Stop. Relying on paragraph 47 of the judgment dated 3rd April 2025, passed by the Honorable Supreme Court in the matter of State of West Bengal versus Boishaki Bhattacharya, within bracket Chatterjee and others, the petitioners applied for reversion to their previous place of work. Stop. Their applications were processed and they were issued letter of reversion. Stop. The time period for reverting back to the earlier place of work expired. The petitioners pray for extension of time to join their previous place of posting. Previous work, not place of posting, previous job kore din. Paragraph D. According to the petitioners, they were unable to revert to the previous job in view of the observation made by the Honorable Supreme Court on 17th April 2025 in the miscellaneous application number 709 of 2025 made by the 2025, wherein the court observed that the service of the assistant teachers not found to be tainted have been permitted to be continued as the students undergoing studies should not suffer on account of lack of teachers and the lapses and failures which have resulted in the order passed by the court. Stop. Paragraph. According to the petitioners, comma, as they were in the midst of the academic session, comma, they were not in a position to join the repatriated posting within the scheduled time period. Stop. Next. The petitioners state that currently some of them are acting as invigilators and examiners of the Madhyamik and the higher secondary examination that is ongoing. Stop. Prayer has been made to extend the period for joining in terms of the order of repatriation. Stop. Paragraph. Learned Senior Counsel representing the Commission submits that as the Honorable Supreme Court Vide order dated 27th October 2025 passed in contempt petition civil diary number 51889 of 2025 made it clear that all candidates will be repatriated by 10th November 2025. Accordingly, there is no scope for extending the period to join in the repatriated post. Stop. It has been submitted that Vide order dated 17th November 2025, the Honorable Supreme Court, Videna, in the order dated, clearly recorded that the candidates have been permitted to join duty in their repatriated posts. And relying on such submission, comma, the contempt proceedings stood closed. Stop. Paragraph. The learned advocate representing the state seeks accommodation on behalf of the learned advocate general. Stop. Paragraph. Upon hearing the submission made on behalf of all the parties and on perusal of the orders passed by the Honorable Supreme Court from time to time in the matter of Boishaki Bhattacharya, within brackets Supra, and the order passed in the contempt proceeding arising out of the above matter, it appears that the court in order dated 17th November 2025 was pleased to direct that if the petitioners have any other grievance or issue, comma, they would necessarily have to seek redressal thereof by way of independent proceeding in accordance with law. Stop. Here, the petitioners have filed a writ petition seeking extension of time for permitting them to revert to their previous job. Stop. Paragraph. The Directorate of West Bengal, Directorate of School Education, comma, primary branch. In item number 5, where they've been repatriated by the council.
Repatriation, my lord, is by the
In all respect of all the students.
the council
Council.
DPSCs are there.
DPSC is. Acha.
So, my lord, this is why, my lord, there are only few writ petitioners who were repatriated
Four.
by a one DPSC. So I
Yes,
only find
council DPSC
Malda.
Malda. Acha. Branch. কি দিয়ে শুরু করলাম? আচ্ছা. Is directed to revert with instruction as to whether the petitioners may be permitted to join their previous job, relying on the order of repatriation. Keeping in mind that they are untainted candidates, comma, were previously in a different job and their job stood nullified by the order passed by this court, affirmed by the Honorable Supreme Court. Stop. Not permitting the candidates to be repatriated will have a direct effect on their life and livelihood. Stop. The matter is fixed for further hearing on 25th of February. Wednesday, just now it was. Why? Yes, we'll keep it on Wednesday is convenient. 25th.
only one.
Order will go down in the other matter.
But only one request, your lordship, where my lordship has recorded that we have submitted that these persons are invigilators or examiners in the exam, as well as my lord, these persons are engaged with the elections duty. Kindly record this as well. They have
Election duty,
been
whether
the teachers.
whether you are in this place or your previous place, that is different.
Appointment as election officers will be going otherwise. So that
And
we are
engaged in election duties.
grateful.
Everybody must be in election duty.
Many of them, not everybody. So as
Most of them rather. The BLOs are the teachers. ঠিক আছে?
this is only why, my lord, the commissioner.
আলাদা order হবে।
My lord, this is only why the commissioner has granted the extension. This is only, my lord, why. The
Now
commissioner-
finished, but that point of time it was there.
Yeah.
Anyway, if some compassion can be shown, yes, primary school teacher is also BLO. এটা কি judgment? এটা কি judgment? No, sorry, sir. Thursdays I take up other matters and it will be difficult. That is the reason. Please adjust yourself. এটা কোন মামলাটা? Who handed over this 3rd April? Please take this back. Yes, the compilation is here. So I do not need this.
The cost of
No,
Next Wednesday.
no,
Again, the other two
I-
papers keep there.
only the verification in 9-10, it has not started, and I have a prayer for an interim order. I don't know if Mr. Bandyopadhyay says it's not going to start within 7 days, no difficulty.
What is the issue?
Well, this is the issue.
All right.
I will finish within 15 minutes. Not even 15 minutes.
What is it?
Lordships need not see the brief at the beginning. All the petitioners belong to the orthopedically handicapped persons.
OH category.
Yes. They got the job in 16 as PH, OH, orthopedically handicapped. Pan India, it is known. I have checked up all the recruitment process. OH equals to orthopedically handicapped. Now, this relates to 9 and 10, not 11, 12, because in 11, 12 situation was because they filed it post, everything was done. This is very big. Now, this time also, we made an application. While we made the applications, we had to see 3 things. Number 1, their advertisement notifications. Number 2, the recruitment rule. And the number 3 is the roster on which basis what is mentioned. The roster which they have followed, if Lordship may straight away kindly see at page 175.
Yes.
Just before that, my lord, if I can just say under section 34, there has to be 4% of reservation for 4 different categories of the PH. My lord, I will go to that later. Now, this is the process has to be done. This roster is made under a 99. There is a state enactment. Under that, this roster is framed. Kindly see 12th vacancy. This is reserved for the blindness and low vision. Therefore, we cannot apply. That's the orthopedically. Then thereafter 32. This is the only place of ours. That's locomotor disability. But they reserve it. So they make it vertical, which is not permissible under the rule at scheduled caste, SC. And next is 42nd. Because 4 they have to show. That is again, this is for the deaf and hard of hearing. So it's not for the OH. And last is 72. 72. This is for autism, intellectual disability, and others. So therefore, so far as we are concerned, who were appointed as
General category.
no, I'm just coming. So we mentioned in the form as PH, OH, orthopedically handicapped. Now, approximate number of vacancies are in 9-10 is 23,000, which means 4% of the 23,000 becomes, let me go not the 4%, 1%, because I'm concerned with on the physically handy, orthopedic, 230. Now, total number of 230 must be in the cadre who belong to orthopedically handicapped. That's a mandate of the central legislation. That's a must. Now, they have made their own calculations. About 196 who should be appointed, that is reserved for the orthopedically handicapped. What they have done is, though we have applied as PHOH, they are treating all of us as general. This is again a second mess up what they did for the SCST. What is the reason? They say, according to us, OH means
Other
other handicapped.
Hmm.
Then I tried to see, is it there in the advertisement?
Hmm.
Answer is no.
Hmm.
I saw the rule, is it there in the rule? Answer is no.
Hmm.
Then I say, is it the thing in practice anywhere in India? I saw just the opposite. Kindly have a look at page 99, NCERT.
Hmm.
Last, Roman 4.
OH.
This is of 2006. I have seen all of the BSNL, even the government of India kindly come to everywhere. This is there is a central government notification, page 186 is the relevant portion. .3. The points 1, 26, 51 and 76 of the roster shall be earmarked for persons with benchmark. Therefore, one for the visually challenged, one for the deaf and others, one for the wage. Now, Lordship, kindly have a look. This 34. Kindly have a look at 34. Bar kore dao.
Persons with Disabilities Act. Actually, wonder.
Take this there.
Yes.
Kindly see, my lord, 34(1). Every appropriate government shall appoint in every government establishment not.
Section 34 you are
Yes,
showing.
but it was opened.
This is rule.
No, not the rule. I am saying section 34. Rule I will
Yes.
come later. Oh, তুমি rule দিয়েছো?
Section 34, yes.
In fact, there is a thing called what is always there in the prejudice in the mind. I told my learned junior, you must be ready with the rule. So he kept that in mind. So irrespective of what I am saying now. Fine. Now 34. Every appropriate government shall appoint in every government establishment not less than 4%. I go by 4%, not even of the total number of vacancies. Lordship kindly mark 23,000 in this case. So 230. In the cadre strength in each group of posts meant to be filled with persons with benchmark disabilities, of which 1% kindly mark each shall be reserved for persons with benchmark disabilities under clause A, B, and C, and 1% for persons under D, E. Now kindly see, so far as we are concerned, we fall under C. So 34(1)C equals to 1%. That means 230 if I go by total number of vacancies. But I am not on the number. Now, under D and E, that is grouped, D and E, it has to be 1%. So therefore, it is the mandate. If there is a 100-point roster, that's a mechanism by which this 1% will come. There has to be one clear cut for wage, and it cannot be reserved for like anybody else. Now, kindly have a look at rule 11(4). Kon page ache? It might be,
Yes.
possibly it's at
51.
page
Rule 11(4).
rule 11(4).
Notice of meetings or what?
No,
It might be at page 51.
1.
Last,
Is it the notice of meetings?
no.
11.4?
It is 11(4) is the rule, my lord. It starts with the reservation of person. Lordship, kindly take the 2017 rule. Where are you gone? What is happening? I don't get it.
দিন আমি বার করে দিচ্ছি।
একটু বার করো তো।
আমি বার।
Just kindly. Why don't you flag it?
Yes, 11.1.
Kindly come straight away. Come to 11(4).
Computation of
Yes.
computation of vacancies?
11(4).
Yes.
The reservation for persons with disabilities in accordance with the provision of 34 of the Act shall be horizontal, and the vacancies for persons with benchmark disabilities shall be maintained as a separate class, which means vertical is, my lord, it's a homogeneous, like SC is only for SC. Now horizontal is always mixture of anything. Now they realized they made a, if I can use the word, a complete blunder in doing this. Now what they have done, just in the, when the process is going on, kindly straight away page 1, the roster on which basis they are going this recruitment, that was at page 175 I have shown, where we don't find our place. Now on 27th of January, they come up with a new roster. There, kindly come to 194.
Yes.
Now I would say now they have learnt, but they have not corrected themselves fully. They have marked, kindly see 12th vacancy. That is correct. That now they have made it unreserved. Unreserved, it is now PWBD, that is a benchmark disability. So anyone will, in fact, ideally, they should identify which one is for one person for each. Even then, now this time 12, 42, kindly come 42. It is also again benchmark, so all can come. 72, also all can come. But 92, in fact, what was the earlier 32 that which they made? No, earlier 32, earlier roster 32 that
Schedule caste.
yes, now they have taken that to 90. So the good thing what they have done, they have made 3 other, that is 12, 42, 72 horizontal. But they have made 90 as a vertical. They kept it only for the schedule caste.
12, 42, 72 is horizontal.
Yes.
92 has been
90, not 90.
90.
90.
Uh,
90
SC
is the same mistake which they did. So that's why I said that they have corrected themselves of 75%. Now the prayer that I'm seeking before your lordships, based on the historical mistake they did. In 11-12, number of vacancies for them, orthopedically handicapped, was 103. Because of this, they treated every orthopedically handicapped as general. 100 vacancies remain vacant. Petition filed, but they came later on, so there was no scope for an interim order. Lordship admitted, and they will file an oppositions. Now in 9-10, our name are there in the preliminary list. Now they are checking. They have not declared us as general, but they will do because they have done. Because
an interview has not been taken.
no, it has not done.
Verification.
The interim order I am seeking is this, following their spirit and the honorable courts. Somewhat different mess up they did for SC and STs. So when your lordship passed an order that you cannot treat a SC and ST as a general, that was an individual order. They challenged before the honorable division bench, and the honorable division bench then extended to everyone the benefit, saying that whoever filed the writ petition by 2:30 for some limited time, we are opening the portal, you correct that. And based on that, it was done. So all I'm praying, I have 2 alternative prayers. First prayer is that our names are the preliminary list. Kindly restrain them not to treat us as general, not to reject our case, which they have done in 11-12. Because we are orthopedically handicapped, we have no scope. We have used the PH. I could have understood that. They show that no matter in Pan India, they have a different acronym. But
1 minute. When you put in the your reservation category, there is a drop box.
yes, what
right?
did I
In
do?
the drop down,
Page 29.
what are the
Yes, page 29. I know. I know. 29.
yes categories?
Category
PHOH.
kindly see PHOH. Now there is a confusion. One question may be put to me, why I did not go for LD, that is locomotor disability. Reason is that is reserved for SC, And they gave a notification also saying, notification. They also publicly notified,
Later on.
clearly saying that this is LD is only for SC, which is their roster itself. This is nothing but saying it publicly that it is for SC, which is already is part of the record that under their 100-point roster.
It has been brought to a notice that some candidates are seeking clarification on the category SC, PhD, PH,
Yes,
LD.
yes. It is clearly stated that this vacancy is reserved for only SC candidates. So that's what the roster. So it's basically their stand as was in the incorrect roster that they have expressed, nothing else. I know. In fact, at page, kindly have a look at page 95. Either they should give it in the advertisement that wage means maybe a scientific formula, different thing, or they must follow what is everyone understands all of it.
95.
Yes, 95.
It is a letter.
It's a letter. We wanted to know,
Yes.
kindly, no, he is not the petitioner. He is one of the orthopedically handicapped persons.
All right.
So
Hmm.
now that the notification, can you see the last but one paragraph from the bottom? Now that the notification and online form fill up list, the categories of disabled people as VH, HI, OH, LDSC. Our submission is that OH category is there. What does OH mean? Or which category does the disabled person? What is it? Basically, they wanted to say that where should we go? Orthopedically handicapped persons
Where
who
should
are
we
not
fit in?
SC, what do we do?
Where do we
Yes.
fit?
Yes. Now, we were treated as OH, means orthopedically handicapped, even in earlier recruitment process. As I said, in Pan India, it is also understood by this. Now, in any case, we have dropped that ourselves OH. Now, for 11, 12, they have whoever orthopedic handicapped persons, whoever applied as PH, OH, they have treated them general. Irrespective of the, kindly have a look at their rule. Kindly take page 82.
Yes.
First, kindly take the definition 2R, reserve category.
Hmm.
Means a category of reservation in respect of scheduled caste, scheduled tribes, other backward class, and here I come, physically handicapped candidates and other categories of reservations.
Hmm.
If any, enforced by an order of a competent authority. So therefore, under R, there is no demarcations by them. Thereafter, kindly come to 11 Roman 2. Sorry, before 11, sorry, I should go to 4 also. Kindly come to 4 Roman 5. That is at page 83.
Hmm.
This is for the duties under 5 to determine the format of application along with brochure, information relating to filling application form and mode of publication therefore. Kindly come thereafter 9. The form of application for appointment shall be such as may be determined by the Central Commission from time to time, and the mode of submission of such forms shall be, kindly see, exclusively online. Everything with them. Now kindly see 11 Roman 12.
Yes.
This is the situations. Our names are there. Thereafter, the regional commission shall verify the credentials and eligibility of the shortlisted candidates appearing for interview vis-a-vis their applications prior to conducting an interview. Applicants whose credentials have been checked and found incorrect by the regional commissions and candidates who are found ineligible to participate in the selection process shall not be allowed to appear for interview. Absence of a candidate during this is not relevant. Kindly see also the next 12. The regional commission during document verification in case of any doubt. Now this is that what they can about the disability level of any physically handicapped candidate may refer the matter to the competent medical authority constituted as per the such and such. Now, kindly have a look at their advertisement. That's the notification itself. That under 13B at page 79.
Yes.
They clarified that if a candidate is allowed to appear in the state level selection test, it does not mean that the eligibility of the candidate has been finally verified. All I'm trying to say is this: whether I am actually orthopedically handicapped or not, yes, you have the entire right up to counsel. In fact, they can do even counseling time also. But on a technical ground, on a misunderstanding of the law, in a situations where also in Vivek Pariya matter, the Honorable Supreme Court also passed an order protecting to an extent that our candidatures cannot be adversely affected. In a sense that if I am orthopedically handicapped, I was working, today they cannot say, no, you are shut, you should be treated as a general, which they have done for the 11 and 12. That they cannot do. Now, what they are doing, kindly also see their own recruitment rule schedule, 89, page 89. There is a NB, right hand side, my lord. For considerations of applications, the SC, ST, OBC, PH categories, certificate issued by the competent authorities of only the government of West Bengal. So now if I see the chain of things, the recruitment rule does not say anything about. No, I'm seeking an right, but no, I have to see because
he prays for interim order.
That case also
No, that case was after.
There it was at a late stage
Yes,
that they came.
yes.
Right now there is a scope for passing
That's
an
what I'm
interim order.
Now,
Do you admit to an interim order being passed?
if what I'm asking interim order is this, may I straightway show what I'm asking, which I'm drawing from the way they have treated when they made a messed up situations, how they created it. Now, kindly have a look at my lord. First, my lord, may I show you first single bench? Kindly have a look at paragraph 23. I will go to the revision bench, but after showing two paragraphs of your lordship. In SCST, that matter, paragraph 23 and 29, because their appeal, yes, Mr. Bandyopadhyay, they are agreed that we are going to give. It's not that your lordship's order was set aside. That's the reason. 23, the notices of the commission that anybody who fails to update or edit their option shall be treated as general category by paying the application fees meant for reserve category cannot be comprehended. And then kindly see 29, the commission cannot suo motu treat a reserved category candidates as general category candidate despite the candidate's disclosure of being a member of a particular reserved category. So that's the definite order of your lordships. The honorable, which was not set aside, the honorable division bench, Kindly take the division bench. Kindly take, my lord, there. Paragraph 11. In course of hearing of appeal, we suggested that appellant should open the portal till 6 p.m. tomorrow, that is December such and such, to allow every writ petitioner who filed writ petitions up to 2:30 p.m. today, that is the December 25, to update their categories. Because if they have a software, their internal problems, they want it should go in a particular way. That was allowed. And based on that, their notification. It was exclusively for the other side. Kindly see, this order was restricted to 11 and 12. But what they have done it, kindly see the notification 16/12. After the Honorable Division Bench order, third paragraph. Similarly, following the spirit of the said order, dated 16/12/25, all candidates of 9-10 who file their application form by paying such and such are also given a final opportunity to edit their categories. So my respectful submission before your Lordship is this. 230 is the 1% of the total number of vacancy. Now,
did you apply in terms of this order?
No, they have. This is in this case. This is for the SC/ST only.
SC/ST.
It is nothing to do. I'm seeking the similar way. There are two ways. One protection I'm seeking. Lordships can restrict it that they can proceed with the verifications, but they cannot treat us as a general and reject our case, subject to result of whatever finally decided by your Lordships. This is one prayer. But other way, as their spirit and the Honorable Division Bench was that it is some difficulty, some technical aspects.
You want them to open a window so that you can rectify?
Maybe, yes. Give it in the publications for 24 hours. If they want it, that no. Because what they want, we should have done it PH. It should be locomotor disability. But
LD.
Now that LD,
Has been.
on that day roster, it was only for SC. Today the new roster has come because the government have realized that's a mistake they have made. So now there are 3 points. Kindly have a look at the roster.
How are they trying to fit in the new roster with the earlier recruitment notice?
There roster is, may I show, roster is made. In fact, it's a Lordship put a very relevant legal questions. These rosters are 99 Act. Are created under a state act after 1999, which banks on the relevant parent act of the reservations. Kindly take. But this is the West Bengal regulation of, it's a long, I'm not reading entirely. Kindly straightway come to section 14.
Yes.
The roster begins with under this act. 14.
Yes.
14. The state government may by notification prescribe model roster for recruitment to post in government establishment or establishment of public entities, statutory bodies, government companies, local authorities in order to ensure that vacancies in such posts are filled up. Kindly see. In accordance with the provisions of this act and any other law for the time being in force providing for reservation for any class or category of persons specified therein. Therein refers to 34 and each. And also kindly see 9, section 9. That refers to the physically handicapped persons. In order to enable the appointing authority to fulfill the requirements of the persons with disabilities, because earlier it was the 95 Act, now it's 16. The employment exchange concern shall forward to the appointing authority a list of registrants being persons with disability for each post reserved for them in terms of the provisions of, kindly see, is chapter 6 of the said Act. So now this chapter 6 now comes to 34 of the 16 Act. And the rules made thereunder. It shall be the responsibility of the appointing authority to mention in the requisition in the number of posts reserved for such candidates to enable the employment. So the mechanism is this. 34 requires 1% for each. In other words, 34 requires 1% for wage. Now 34 has to be implemented in a mechanisms under 99. But 99
Yes. Just wait. Yes.
Yes, my lord.
Yes, continue.
Yes. No, I don't do that because there is a suffering that I'm
Yes,
seeking
then-
an interim order. That's the reason.
Something you have said there, and before having never believed,
Yes.
you are not trustworthy.
Yes, please,
We are
do
on
not.
Camera. What we are
All
doing-
this can go on outside the court, please. Yes.
Okay.
Hmm.
Okay. I don't want to play the game in your game.
Please.
I would be
Please do not make any comments. Yes. Hmm.
okay.
Yes, please.
Yes. Then, my lord, my lord, so the central legislation requires 1%, which is equivalent to around 230, but here they have made it 196, but I'm fine with that. 196 for the
All right. More or less, I've understood. Let me
So-
hear.
But today, my interim order I'm seeking two.
All right.
Yes, well, I have already. These are my respective.
Yes,
submissions.
please.
First of all, the roster has not been challenged.
Hmm. Which roster?
Number 5, etc.
Is it page 174?
It will not challenge.
There is another roster,
Okay.
but page 194.
I'm seeking benefit.
Hmm.
He has accepted that one.
Hmm.
If the roster has been accepted, there is no challenge in that.
Hmm.
For the second roster, roster will find from the second roster.
27th of January 26.
This is from starting long back. Law was applicable at that point of time that is good. Day of date cannot be changed.
Hmm.
And that is the constitutional judgment of constitutional judgment. That is the case of.
Yes, that is very settled. Hmm.
There was second roster question does not come.
Hmm.
Second roster will come only next year. First roster is going to exactly work on. But if the first roster is bad, illegal, that challenge has to
Hmm.
that has challenge has come. Then we have to then I am coming to the other. Another kind comes. Another kind comes to case
100 and?
130.
Yes.
This is determining certificate. These are the determining.
Yes.
A. In the case of local service only. Not wage. He is telling his case that the wage has not been, then he is certificate is local
Hmm.
and can it be 124 also says local. In this case cannot be that the local disability wage. Case
No, you say OH is other handicap.
other handicap.
All right.
Wage is other handicap.
Where will a candidate get to know that OH is other handicap? Because there are other recruitment processes where OH is treated as the orthopedically handicapped.
But we have said it there, we have handed over one document.
Yes.
In
19 June 2025.
it has been brought to one which is some kind of clarification on the category of AC gas MD.
Hmm.
It is clearly stated in vacancy is therefore on this particular criteria having locomotor disability and following necessary certificate by the respective competent authority on or before the last date of submission of application.
Hmm.
So we have clarified.
This is for SC. Suppose this candidate one,
There is an SC locomotive disability is there, that is also there. He is not paid since less. Only the
a general category candidate with locomotor disability, where will he go?
No, their general category candidate locomotive. What is law? What is the law? 1% has to be paid. This is the law that 1% has to be paid for general or half percent.
The Act says so.
1%.
Yes.
So 1% for SC. If I have
Where from are you inserting SC over there?
1%.
1%, it includes all, in everybody.
Out of 1%, SC, ST,
Everybody.
everybody is there. 1% SC, 1%.
Where from is this SC coming?
But SC is coming from that. Is
Where?
That is according to roster.
Whether the roster.
If the roster is not challenged, roster is accepted. That's exactly my argument. The roster is not challenged. And you have to go by the roster. Otherwise, your roster has to declare roster is illegal. The way your roster will declare.
No, but then right now your submission was that 1%, it includes everybody. In general, as well as the SCSTs and whoever. Right. But
Their
the
horizontal, vertical have been kept together.
here,
Horizontal, vertical is a general case. When we read horizontal, but when it's specific, 2016, the act has come.
yes.
After 2016, it has been made SC. Earlier it was not SC. Therefore, SC has been made. Within the SC, if there is a candidate, then he will be fitted.
And general cannot be fitted.
General cannot be
Where will the general go?
fitted.
Where will the reservation?
80 chart, that is also not right.
No, the law says so. The Act says
1%.
1%.
Yes.
It includes everybody. And you have the roster says it is only the scheduled castes.
Yes.
Where will the general candidates go?
General candidate, if this scope, if this roster scope in the roster is not there, not there.
And that is illegal.
Well, if it is illegal, then the challenge has to be made.
Assuming the challenge is not there.
No.
But it is something which is palpably illegal according to you also.
Not according to me. That's only federal government. Your mission, roster,
Central government.
recruitment notification, page 9.
96.
Yes. It goes to the instruction website transfer to find the National Council of Education Research and Training, an address organization for education research training and development of instruction methods in school education invites online application of 170 pages. Roster has got it. That's another material kind come to clause 9. Then number 9. Go to the extreme right hand side. Extreme right comes. ST reservation. Associate professor ST dash PH.
Visually handicapped.
OBC HA. There were categorization of the student caste and student tribe OBC. It is there.
See, the acronyms are mentioned in page 99. VH is visually handicapped. OH is orthopedically handicapped.
No, therefore SC cannot only, it has to be done in general case, it's not correct according to my submission.
Whether OH, as there are several advertisements where OH has been treated as orthopedically handicapped.
Yes, and next come 17 OBC 18.
Do not go to those specific points. It's OH or LD. This is the issue. OH or LD.
Correct.
Right?
OH or LD.
OH or LD.
LD. Now, what is his certificate?
His certificate.
His certificate is 130.
Do you all have LD in the drop down boxes?
Yes. It is there. It is there.
LD is there.
এইগুলো ছিল স্যার ড্রপ ডাউন বক্স।
LDSC. Its drop down is clear.
এইটা 16 ডিসেম্বর।
Yes.
SC PH that credit.
That is only for the SCs,
Doctor,
where roster is different. Roster will come later on. Where will an orthopedically handicapped category fill in his application form? Then
very good.
where will OH go?
If the vacancies are not there, what can be done? I go by the roster.
No, vacancy is different. Vacancy point is different. A candidate has to fit in his application first. First, for applying in a recruitment process, first step is application in the recruitment form.
That is his part.
You-
Not my part.
It is your part because you make the application form.
What is my vacancies come here?
Go to the vacancy later on.
One. Just bear for one. There is my. Just which is going on there. It is coming from there. With the roster. With the roster. I cannot change the roster. With the roster. Never do. The moment
One maybe make an application giving a certificate of a locomotive disability, whatever it may be. His claim is on the basis of the certificate. Whatever he is saying in the application form, it is not sacrosanct.
This is your form.
No, what he is saying in the application form, it is not sacrosanct. His details, whatever he is filling up, I am telling that.
All right.
This is subject to scrutiny. And at the time of the scrutiny, he is giving this certificate,
LD certificate।
LD certificate.
Till now, you have not scrutinized.
That's
It is
Why?
at this stage.
Very nice. This is the document he has annexed. I have not annexed. This is his document. So on the basis of this document, where is the scope? He will not create another document. I hope so.
That means in the application form that you have floated for recruitment, there is no scope to fill up an orthopedically handicapped category, general category candidate.
There is no form. That is, your lordship is correct. There is no, in that place, there is no scope to do it.
No scope to do it.
That is, your lordship is absolutely
All
correct.
right. In that case,
Uh.
what you are doing is you are treating a physically handicapped category candidate in a reserved category. Can you do that?
Yes, on the basis of the roster.
That means you are not allowing reservation to a reserved category candidate.
I am allowing a reserve candidate, scheduled caste, SC,
Scheduled
that is
caste
also
is-
reserve category.
Scheduled caste is you
Scheduled
are
caste
allowing, but
not-
general you are not.
No, there is no scope to do it.
There is no scope to do.
There is no scope to do it.
ভ্যাকেন্সি
Now, Millard,
ডিসপ্লে করে দিচ্ছেন ভ্যাকেন্সিতে
Yes.
kindly see the vacancy.
ওটা একটু দেখিয়ে দিন না
কোনটা?
একটু দেখিয়ে দিন তো স্যার দর্শককে ডিসপ্লে করে দিচ্ছি
Millard, kindly, I am displaying this.
এটা ভ্যাকেন্সি আমার কাছে যদি না থাকে আমি কি করে করবো এখানে জেনারেল এলডি নেই তো যে কোনো পেজ
Millard, take one Bengali grade.
Bengali?
Grade, kindly see from this display. Display book.
নেবেন না
Uh-huh.
See, you are 880, male, female, 330.
Yes.
ST 122, 46. SC 439, 166. OBCA 20978.
Which one you are reading?
My lord, Bengali grade, assistant teachers.
First page,
First page. We'll give the affidavits. My lord. We'll give the affidavits.
Yes.
Lots of got it. My lord.
Hmm.
Now see, you are 880, male, female, then female is 330. 330 reserve. ST 122, then 42, 46. Then SC 439, 166. OBCA 20978. OBCB 146, 55. URPH BH 21.8. URPH HI 21.8. URPH OH 21.8. SCPH LD 21.8. EWS 210.79. Bengali 2090 786. If it is not there,
This is the vacancy statement.
yes, vacancy statement. I cannot go beyond that, my lord. That is also under the act.
Is it?
Vacancy I have to accept. Process is this, the vacancies would be informed to us. Vacancy position will be given to us. Advertisement will be, we are the facilitator rather. This has been given to us. That this has not been challenged by any point of time. And my lord, kindly see, just take this 2025 months, kindly see. Paragraph 19. Kindly read below paragraph 19. It is no longer as integer that the terms of an advertisement issued in connection with the selection process are normally not open to challenge unless the challenge is founded on the ground of breach of Article 16 of the Constitution or, for that matter, Article 14. Once an advertisement is issued inviting application for public employment, it is the responsibility, nay, duty of an aspirant to read and note the terms and understand and what his requirements are. If any aspirant finds any of the terms ambiguous and there is scope for an inquiry inbuilt in the advertisement or is provided by any rule regulation, an effort was to be first made to obtain clarity for understanding the requirements accurately. If no such scope is available, nothing prevents the aspirant from seeking clarity by making a representation. Should each clarity be not provided, the aspirants may participate in the process without prejudice. However, if the aspirant does not make any such effort and takes a calculated chance of selection based on his own understanding of the disputed term, on his own understanding, we are not messing up, own understanding, or it would not be open to him to challenge the selection on the ground that the disputed terms is capable of being entertained such plea of ambiguity while preferring to accept the recruiting authorities' understanding of the said term. This is for the simple reason that the recruiting authority is the best judge of what its requirements are, and it is such understanding of the recruiting authority that would matter most on cases brought up before the court. Hence, after the commencement of the process, when aspirants have participated without raising any demur as to what a particular term means, even if any of the terms be ambiguous, as the court should deal in favor of the recruiting authority. Now, roster is a public document. Roster is a public document. You didn't challenge the roster at that point of time. They should have come before the selection process, even after filing of the application. Now, at this stage, how it can be entertained? Roster is a public document. And I cannot go beyond this. Now, my lord, kindly see the...
Who's for the state in this?
My lord, kindly, Mr. Vivek,
Are you there?
there? Just, I will finish it, my lord. Just kindly see the second notification. He is asking for the reliefs in that line. I hope he has messed up his client. See the notification, all that,
194.
page 194. Right? My lord, kindly come to the notes. Kindly come, then I will not give you clauses trouble. Clause 2. The governor is also pleased to direct that a reservation for persons and with disabilities as provided under subsection of section 34 of the Right of Persons with Disabilities Act 2016 shall be implemented as follows. A. 4 roster points reserved for the PWBDs in the model 100-point roster will be genetic in nature and hence not earmarked disability category wise. Disability category wise allocation will be determined only at the stage of recruitment based on actual appointments and maintenance of disability category wise register in every government establishment. B. This detailed guidelines regarding implementation of reservation persons with benchmark for distribution disabilities for the service and post under the governor of the West Bengal, government of West Bengal in the model 100-point roster of vacancies and maintenance of a duplicate disability category wise register in every government establishment will be published by the Department of Women and Child Welfare, so and so, so and so, so and so. Now, this is at the time of when the process of recruitment is started.
At the time of credential verification, will you give them an opportunity to show their LD, OH, whatever?
The question doesn't come now.
Right.
Question, according to us, the question doesn't come.
Right.
Now, he has relied upon your lordship's order.
Where?
27th, which I went to appeal court earlier. SC. Now see the division bench order. There was a tough contest of the matter. Now, that time.
And that time you accepted to open a window.
No, kindly just read this. Read this, please. Paragraph 11. In course of hearing of the appeal, we suggested that appellants should open the portal till 6 p.m. tomorrow, that is December 17, 2025, to allow every writ petitioner who filed writ petition up to 235 to answer. Learned senior appearing for the appellant submits, the appellants are agreeable to do so. Now, but during the course of hearing, court has suggested that.
And you accepted it?
Yes, accepted. That's correct. It is not that I have not accepted. And my luck is this. Unfortunately, wherever I have given a concession, that is taking as a right. Sometimes I wish to be very liberal, and I am a liberal person. Now court pressure and others pressure, I would not be liberal in the future. And some persons, not Mr. Dot, some persons takes it under the pressure of the court, it has been done. Go and keep quiet.
Nothing of that sort.
No, I am telling to your lordship, since your lordship has said that you have given the consent.
Not concession, it is
concession.
You have agreed to the
yes, suggestion. Yes. Otherwise, court has understood what is the argument I had made.
Yes.
Now for 20, and this is only for the civil caste civil type.
Only
and long back.
Long back.
It has been long back. Now, my lord, kindly see the notification, 16 December 2025. The notification, he has given the notification.
Yes.
Kindly see. Writ petition should have been filed. One of the condition was there. That time writ petition was not filed.
No, this is for SCs.
Kindly see. Come to last but one paragraph. Failure to their respective categories within the stipulated time as indicated in the said solemn order.
No, who is going to whom this public notice applies?
Including PH.
SCPH.
No, SC stroke, ST stroke PH. Can you read it? And kindly see before that. Similarly, following the spirit of the said order at 16 December, all candidates of class 9 and 10, we have not restricted class 9 and 10 so far pending writ petition is concerned. They are class 9 and 10. Now, similarly, following the spirit of the said order, all candidates of class 9 and 10 who filed their application forms by paying an application fee of 2 are also given a final opportunity to edit their categories SC, ST, PH up to 8:30 p.m. on 17th December. Now this chance was also given to them. They have not responded.
Where will they fit?
My lord, ultimately falls down to the same question. Since options argument has been made, that's the reason I am arguing. Otherwise, I would not have argued.
No, where will they fit?
No, there is no scope.
No scope. That means they have to be treated as general.
My lord, we are treating them as a general. They should have been cancelled because 200 rupees has been given.
Because they are physically handicapped.
Physically handicapped. The now we are not. This is not a physical. We are treating them as general candidate.
That is your problem.
Not my problem. If the problem has been created by the roster, and that was open, is a public document which was not challenged at any point of time.
All right, I follow.
And after the selection has started, after participating in this selection, one cannot challenge. There are number of judgments are there. I can cite to your lordships. So.
I was just a
And I will be submitting that I want to file an affidavit. And kindly, beloved, do not interfere with the selection process now. Do not pass any interim order.
All right, just 3 sentences. Page 74, there
No, I
will hear you.
Wait.
Because state will be required. I just want to know, prior to you starting, what prompted you to come up with what prompted? Go. You can also go.
One thing, my lord, before your lordship, my lord, had a puts a query on the state, my lord. That very question, my lord, I am in item number 7, my lord. These 20 roster, my lord, previous roster, 32nd roster was challenged by me. And it was previously heard by your lordship. Thereafter, it is being heard by a coordinate bench. There, my lord, the bench was of the opinion that prima facie this is incorrect. Horizontal reservation, cuts across vertical reservation, so it is incorrect. During pendency of that, my lord, the state comes up with this new roster in supersession of the earlier roster. Now, my lord, presently, because of that writ petition, my lord, the new roster has come up. My lord, yes, I can.
You are not that.
No, I have the documents, my lord. I have the documents. I can show that, my lord. Secondly, my lord, at this present time,
You can leave. Because it's already 2 o'clock will start. You can leave.
No.
Continue.
How many time is it? To be counted.
32nd roster is now not in existence. Now the new roster has come up. What we want, my lord, now the recruitment will be governed by the new roster.
Why will the old one not be there?
It is the new roster has been framed, my lord, in supersession of the earlier roster.
Yes, show me that.
Yes, my lord, it is written, my lord. Your lordship is item number
after recess.
My lord, your
Cannot
lordship is
speak.
in item number 6. I am showing
You
from
all are making submission. The court is not making submission.
50 minutes.
Please
Let all
go.
of us have lunch.
Please go. Please go. Your turn is over. The commission has made submissions. You can leave now.
Page 198.
Yes.
of item number 6, my lord. I am showing from
198.
198, serial number 11.
if your lordship kindly says that.
Yes.
In fact, my lord, that I was kindly see 74.
Oh, 1 minute.
Yes,
Let
yes.
him make
My lord,
submission.
since in serial number 11 it is stated that in supersession of the earlier one, my lord, this has come into effect. Now, my lord, the SSC cannot rely upon the old one in the new recruitment. So what we want, my lord, we are not saying that we have filled up as OH. Now what we did, my lord, has been superseded by this one. According to this, my lord, we can apply as physically person with benchmark disability. There is no OH, there is no LD, there is no VI, nothing. According to the new roster, there are 3 points where we can apply under the heading person with benchmark disability. Since the commission the state has brought a new roster, my lord, according to the new roster, we are entitled to edit our application with person with benchmark disability because the earlier roster has been superseded.
All right. But this super session will be effective on and from the date of the notification. You
My
cannot
lord,
say that it will have
To this,
retrospective effect.
my lord, the new roster, earlier roster, the 32nd roster, your lordship knows, advertisement was published on 30th of May. So, my lord, the roster which was in prevalent before 30th of May would have been followed. That roster was also followed from 13th of June 2025 after the advertisement came into force. Kindly see the old roster of 32nd. Item number 6M, my lord, get to page number. 173. My lord, page 173.
13th of June. 13th of June?
Yes, my lord.
Yes. This
So
is
the advertisement was published on 30th
30th
of May.
of May. Yes.
Yes, amendment may have been made. Kindly see. My lord,
1 minute, 1 minute, 1 minute. No parallel arguments, please. Yes.
my lord. So, my lord, amendment, it's correct. Amendment was in 2019, but it was incorporated in the new roster in 2008 on 13th of June 2025. But the advertisement was published on 30th of May 2025. So it was after the advertisement which was incorporated. Now, in the
Prior
course-
to this 13th of June, which roster was being
my lord,
followed?
that was roster of 2000 subject, most probably of 2019 or 2012,
Twen-
which does not, my lord, it was prior to 2016 because the 2016 after the PWD Act came into force, the new roster was amended only in 2019. Prior to that, the 2012 roster
Page
was-
169,
was in existence, my lord.
169, 2011.
2011
Yes,
roster.
that is there.
That was
But
prior.
that was prior to the act coming into force.
That
Yes.
is unreserved.
After the act came into force,
roster is-
173. First roster is 13th of June 2025.
My lord, the first.
In the meantime, the recruitment processes which were conducted, was it in accordance with the 2011 recruitment?
No, my lord. After 2011, another roster came
Ah.
in 2019.
2019.
And the new roster, 32nd roster was incorporated, changing the OBC vacancy status, my lord, also.
All right. I just want to know from the state what prompted you to come up with this 27th of January
Why?
Yes.
by making the corrections only in the
Only in this.
physically handicapped
only.
category.
But I must admit to your lordship that it is an argument which I am taken to take on before your ladyship out of the blue. Why I tell your ladyship this? Because going back on the same arguments which have been made by Mr. Bandyopadhyay, but not in the same light as I want to show it before your ladyship. The prayers have not been placed before your ladyship. The pleadings have not been placed before your ladyship. The case of the petitioners is that they did not know what OH mean, right? Kindly takes up item number 7 because I am ready with that. Item number 7's petition, or if I may read paragraph 10 from
No,
that.
they say that they thought
So
OH is
let us
orthopedically
come back to that.
handicapped.
And yes. So say I am OBC. I know I am OBC. So I need to know what OBC means, right? If I do not know what OBC means, I will not go and apply for SC or ST. At the same time, they know what they are LD, locomotor disability. They, by the notification which has already been handed to your ladyship, know that what LD means, right? So there is no place of confusion at all. Number one. So if that is a mistake, that is a mistake on their part. Applying for OH. Number one. Number two is they now say that this LD, and that is also probably passing through
Now
his
you
mind.
do not take up the stand of the commission.
No, that is
I
not.
just want to know what prompted you to come up with
I'm coming.
27th of January 26.
That is what I was telling.
Yes.
That SC, LD, their case, why I'm saying that I am being called on to answer a different case altogether. Their case is that this SC, LD,
You forget what their case is. You say what is your case. What
My-
prompted you to come up with this
this is
notification?
the case which I am being called on to answer before your ladyship out of the blue. It does not concern with this whole petition.
Yes.
There is a query of the court.
I will come
You
back
have-
with the instructions on that.
You have come up with this 27th of
Yes, I will
January,
come back. I will come back with the
And
instructions on that.
13th of June 2025.
Yes.
What prompted you?
I'll have to come back on the instructions with that,
Right,
Milord.
then that is all right.
Milord, but before that, may I even I,
Kindly see my
Arre
prayer.
Baba,
See,
if
he's
I
saying that
can
it is
place,
not-
if I
yes,
can place my
anything
case in my own way once.
7,
Prayer
in
C, my lord,
para-
item 7.
item 7.
My lord, may I read? You don't.
All right, all right.
May I place my case in my own way once.
Or in the nature of mandamus, commending the to consider the candidature of the petitioner under 3% horizontal reservation quota for unreserved person with unreserved person with benchmark disability as per the new notification dated 27/1/2026. So, my lord, my specific prayer is this.
So may I place my case once at least in my own way, just once.
On the next day, because this is the query of the court. You are not as such a necessary party over here.
Yes, yes.
It is only the vacancy notification, the roster rather, which is creating a little bit of problem.
I understand, Milord, why your ladyship has asked this question. I get.
Yes. So these candidates, they claim to be of general category and they are physically handicapped. Where should they be given the benefit? This is only thing.
Yes, let us
Nothing-
presume on the basis, just 1 minute if I may get. Let us presume on or proceed on the basis that it was completely wrong. Completely wrong, not giving them a chance to be fitted. You are LD. That is what I understand. You are PHLD. There is no scope for them to participate as you are PHLD. So they are left to participate as simply you are,
General.
right?
As general
You are
category
unreserved category candidates. Let's say that it is completely wrong.
Hmm.
When do they challenge it?
Yes.
Before participation. Once they participate without raising any demur, they cannot now turn back and challenge it. Number one. Number two is that too at such a belated stage after completion of everything.
No, here it
This
is
is
not
90.
completion.
No, no.
That's the reason. Other matter, the court did not
Yes,
interfere.
yes,
because
yes.
It had proceeded to some
But
extent.
on this,
Here, it has not proceeded
Yes.
to that extent.
but that portion your ladyship may kindly be pleased to consider. One second, please just portion of my argument your ladyship may be pleased to consider that there was no question or no place of any confusion. Number one, they knew what SC means, they knew what PH means, they knew what LD means, they have also the certificate of LD. In fact, in paragraph 10, they say that they were previously OH, now they are LD. They have known this throughout. There is no question of any confusion. Number one. Number two is if they say that not providing any reservation for UR, PH, LD is bad in law, they should have had challenged that at the very beginning without any challenge or raising any demur. Once they participate, that too on a misdeclaration, I am ready to accept that it is a mistake on their part, but they are ousted quite rightly and they cannot now turn back and challenge. Number two. Number three is as far as the roster is concerned, the applicable roster, they have not challenged it then, they have not challenged it now. So even at this belated stage, without a challenge to that roster, they cannot seek to sustain this petition before your
Alright.
ladyships.
My lord, your lordship has seen that drop box that is.
Yes, yes.
Page number, paragraph.
Not getting OH.
Yes.
We say, my lord, there is nothing. All this PWD reservation in terms of this 2016 Act, they cannot go beyond this. According to the 2016 Act, there is nothing called OH, other handicap, nothing. So, my lord, a man of reasonable prudence, I initially had a certificate. After this 2016 Act, orthopedic handicap and now being known as locomotor disability. I found that in the drop box, it is OH. Any man of reasonable prudence should think that OH stands for orthopedic handicap, provided if there is other connotation of OH under the PWD Act. If your lordship kindly see section 34, there is nothing of that sort that OH connotes other handicap.
Challenged it.
But one small thing, the very advertisement at page 74, kindly take 74.
Yes.
It begins with.
Yes.
So this is not a simpliciter advertisement. In terms of the judgment of the Honorable Supreme Court, it begins with that. Now, the Boishaki judgment, paragraph 49, it clearly says they cannot oust us. 49. Can you take paragraph 49? In fact, they are supposed to give concession. 49. The disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required, with age relaxation and other concessions. Now, I'm not others are not necessary.
Hmm.
Now, coupled with this, Vivek Paria, 20, kindly see this one, 26/11/25.
It will not adversely affect your
Yes,
case.
how they can oust us?
Rules are not infringing.
By virtue of the main judgment, being a part of the advertisement,
বলে দিচ্ছি
and I got the job as
বলে দিচ্ছি বলে
wage.
দিচ্ছি
Now by this technical, this, that, how they can oust us?
The rules have not been changed. The roster, this is a question of roster. I'm very sorry to interfere, but the rules have not been changed to their detriment. The
Not
roster has been.
Required. This law, coupled with the Honorable Supreme Court judgment, you cannot oust me, you cannot treat me general.
Yes. Ladyship, I will
You
not.
have your earlier certificate where it was mentioned as orthopedically handicapped, now changed to,
That is the admission also. At paragraph
I
10.
can bring that, it is not there. It is,
but you had it.
yes, yes.
Wait,
In fact, my last job, in fact, there was an, this was,
annexed.
this was my,
No, the last last
in fact,
job.
incidental, it's a coincidence that the petition number 1, there was an order by your office and thereafter, one should not be like a scientist in a laboratory trying to find out.
In compliance of such and such, that in the petitioner was a waitlisted candidate, PHOH. In order to comply, writ petitioner allowed 1 mark and came under the zone of consideration. And this OH is orthopedically handicapped.
I say that physically handicapped persons, I got the job by virtue of the Honorable Supreme Court's order. Even if 34 is not there, my lord, they cannot treat me suddenly as a general.
Lord, I will not make any further submission, but it is my duty to point out to your ladyship, my lord. In 11-12, similar challenges were made. I draw your ladyship's attention to paragraph 9 only for the purpose of interim orders.
11-12, this new roster needs admission. That was not even there.
No. Let me at least place my case. Paragraph 9, the primary reason by the court is that without challenging the roster, this challenge could not be sustained, sir.
Simple.
No. By the coordinate bench. By the coordinate bench.
In fact,
I'll not elaborate on this. This is just for your ladyship's my lord, assistance, my lord. That is all. And another thing, I'm not in 6, my lord. I'm in 7. I would be saying
6, somebody must
yes,
be there.
he's there.
Please come.
all our names there in the preliminary interview.
The petitioners, item number, the petitioners claim to be physically handicapped category, category candidates with benchmark disabilities. hyphen দিয়ে locomotor disability. Stop. They were initially issued the reservation certificates by mentioning that they were orthopedically handicapped. After the implementation of the Rights of Persons with Disabilities Act, 2016, they have been issued reservation certificates by mentioning that they have locomotor disability. Stop. The petitioners participated in the recruitment process conducted by the West Bengal Central School Service Commission -SLST 2025. Stop. They filled in the application form by disclosing their category PH-OH and paid the application fees meant for reserved category candidates. They are aggrieved as their candidature has been treated as general, that is unreserved category. Stop paragraph. Submission of the petitioners is that there was no scope and or opportunity for the petitioners to disclose their nature of handicap, as a nature of disability in the application form. Stop. The reservation for the orthopedically handicapped or candidates with locomotor disability has only been reserved for the scheduled caste category candidates. Stop. For the unreserved / general category candidate, there was no opportunity to disclose their disability. The petitioners filled in the application form by disclosing their category as Stop. It has been submitted that by if the petitioners are not being provided the reservation in terms of the act, then the same is illegal. Stop. The same is also contrary to the judgment passed by the Honorable Supreme Court on 3rd April 2025 in the matter of State of West Bengal versus Boishaki Bhattacharya Chatterjee and others, paragraph 49, wherein the court specifically recorded that the disabled candidates will be allowed to participate in the fresh selection process, if required, with age relaxation and other concessions. Stop. The same is also contrary to the order passed by the Honorable Supreme Court on 26th of November 2025 in the matter of Bibek Paria and others versus State of West Bengal and others, wherein the court directed that the High Court shall also be mindful of the fact that the untainted candidates in the past selection were allowed to sit for the selection tests to be held afresh, and their candidature cannot be adversely affected by application of the new rules. Stop. It has been submitted that the Labor Department of the state has published a notification on 27th of January 2026 by disclosing the by publishing the model 100-point roster of vacancies Stop. The commission ought to vacancies. The said notification has been made in suppression of the department's earlier notification dated 13th of June 2025. Stop.
Supersession, probably, your leadership.
Supersession, not suppression. Supersession. The commission is following the 100-point roster published by the department on 13th of June 2025. Stop. The commission ought to follow the roster which was prevailing on the day of publication of the recruitment notice, and not the one which came in the midst of the recruitment process. Stop. Prayer has been made. No, an interim prayer has been made to direct the respondent commission not to treat the candidature of the petitioners as general for the time being. Stop. The submission of the petitioners, submission and prayer of the petitioners is opposed by the respondents. Stop. It has been submitted that the recruitment notice has been published keeping in mind the vacancy statement received by the commission. Stop. There is no vacancy reserved for the general category physically disabled candidates. Stop. The reservation is disabled candidates with locomotor disabilities. Stop. Locomotor disability candidates in the scheduled caste category has only been reserved. Stop. There is no provision for reservation of unreserved physically handicapped locomotor disability candidate. Stop. It has been submitted that the 100-point roster not being challenged, challenged at the initial stage, initial stage or in the instant writ petition, the roster cannot be interfered with by the court. Stop. As there is no provision for reservation in the roster, there is no scope for providing any extra benefit of reservation to the petitioners. Prayer has been made to dismiss the writ petition. No, dismissal aage. Prayer has been made to permit the respondents to file affidavit in the writ petition. Stop. Paragraph. The learned advocates representing the respective parties have placed before the court Section 34 of the Act, which mentions that every appropriate government shall appoint in the government establishment, not less than 4% of the total number of vacancies in the cadre strength in each group of posts meant to be filled with persons with benchmark disabilities, of which 1% each shall be reserved for persons with benchmark disabilities, namely blindness and low vision, and locomotor disability, including cerebral palsy, comma, leprosy cured, comma, dwarfism, comma, acid attack victims, and muscular dystrophy. Stop. Rule 11 of the Rights of Persons with Disabilities Rules, 2017 has been placed. Stop. The same mentions that for the purpose of computation of vacancies, 4% of the total number of vacancies, including vacancies arising in the identified Rule 11(2) within bracket 2, English 2, mentions that every government establishment shall maintain a vacancy based roster for the purpose of calculation of vacancies for persons with benchmark disabilities in the cadre strength as per the instructions issued by the appropriate government from time to time. Stop. It has been submitted that despite there being provision in the Act for reservation of vacancies for the benchmark disabilities, the candidates having locomotor disability have not been provided with the benefit of reservation. Step next. The paragraph. Admittedly, the roster pursuant to which the recruitment process is being conducted has not been challenged. Stop. Next. The issue is can a candidate with benchmark disability be treated as a general category candidate contrary to the provision of the Act, irrespective of the fact whether the keep it over there only, not irrespective. The sentence ends there. Stop. It has been brought to the notice of the court that the petitioners are participating for recruitment in level in classes 9-10 level. Stop. The preliminary list has been published, but the process of credential verification is yet to be conducted. Stop. Next, the petitioners feature in the list of features in the preliminary list. Stop. As the issue has to be decided upon exchange of affidavits, let affidavit in opposition by the respondents be prepared and circulated within a period of 4 weeks. Reply, if any, within 2 weeks thereafter. Stop. Liberty to mention the matter for hearing immediately on conclusion of the aforesaid time period. Stop. As an interim measure, comma, the commission is no, not as an interim measure. The commission, now during the pendency of the writ petition, the commission may proceed with the credential verification and steps further thereto. But the candidature of the petitioner shall not be rejected outright at this stage by treating them as general category candidates. Stop. The fate of the candidature of the petitioners shall abide by the result of the writ petition.
That item number 7 states
Same order.
absolutely same, only one difference. Item number 6, they are in-service candidate and we are freshers. But there is
And then there is hardly any difference whether in service or fresher. It can go on in the same way.
Your lordships add just one sentence. Lordship has referred the rule, but the rule 11.4 where horizontal has been referred. Lordship has referred 11.2.
11.2.
But 11.4 is where it made it compulsory horizontal. Therefore, it can't be reserved for SC.
11.2 আছে 11.4 টাও লিখে নিন। The reservation of persons with disabilities
Horizontal.
in accordance with the provisions of section 34 of the Act shall be horizontal, and the vacancies for persons with benchmark disabilities shall be maintained as a separate class.
Deeply obliged.
যেখানে 11.2 টা বললাম সেখানে এটাকে দিয়ে দেবেন। Affidavit of service and the payment of deficit court fees. In item number 7, there is
that I have given, my lord, deficit court fees and affidavit of service.
Right. Well, deeply obliged.
Deeply obliged.
I was thinking of continuing, but my officers have to be given a little bit of respite.
Yes.
Had it been 3:30, I would have continued, but there is no early rising today.
There is a
So I'll go and I'll come back.
You have to do any fasting. Neither do I.
No, I'm not fasting, I'm drinking water. Thank Seven কি হলো? Oh, 7 হয়ে গেছিল, 8. Yes.
Before I begin, my lord,
Your Lordship, Mrs. Bhattacharya is appearing for the board in this matter, but we have not received the brief yet. Over telephone, we have been informed.
my lord,
Kindly make
board,
it not today.
board has been served on 13th. But this is the board has been served on 13th.
What is your prayer?
But kindly sees, my lord has heard the case of this petitioner before. She is an approved headmistress.
All right.
Circumstances compelled her to seek transfer. She was initially granted transfer.
Yes.
In course, before implementation of the transfer order, my lord will kindly find my lord's earlier order at page 168. My lord had given leave to challenge the cancellation of the transfer and other orders. Paragraph page 169.
My Lord, kindly make it not today.
1 minute. 169. Yes.
My lord has seen that.
State relies upon instruction.
Paragraph 11. It will be open to the petitioner to initiate fresh proceedings challenging the subsequent cause of action. The subsequent. Let me at least have the decency to permit me to complete.
All right. Issuance of a disciplinary action, these steps were taken. You
Yes.
wanted to challenge. Now, this is the challenge
Yes,
to
this
the
is the
disciplinary
challenge.
proceeding.
The grave urgency is, my lord, the circumstances which compelled her to seek transfer was that, in simple words, her life was under threat. That is, my lord, manifested, reflected in the reports of the Director of School Education and DI also. So they had readily, my lord, acceded to a prayer for transfer. Then, my lord, at page 149 is an order which sort of changes the course of action. Page 149 dated 12th December 2025.
Yes.
This is coming from the Deputy Secretary to the Government of West Bengal. Kindly sees, my lord, a direction to initiate disciplinary proceedings. Immediately the next day, page 150, but my transfer is kept in abeyance by the, under orders of the President, presumably, by the Secretary, West Bengal Board of.
Yes.
And the suspension order is at page 159.
Fifteenth of January, 26.
So there is already a decision to initiate proceedings. The rule contemplates a show cause, a reply to the show cause, consideration of that reply, and then, my lord, application of mind to that reply, and then a decision if it is not satisfactory to initiate. This, at the dictate of a third party, the disciplinary authority cannot initiate disciplinary proceedings. This is my first case.
What is the interim relief you have praised?
Interim relief, apart from the stay of the suspension, my lord, a gravely urgent thing is that, my lord, kindly sees the show cause, the frivolous nature of the allegations. Page 165.
All right.
The absence of.
1 minute. This was issued on 15th of January.
Yes.
Today we are on the 17th of February.
Yes.
More than a month has passed.
Events are, my lord, moving day after day. My lord, kindly sees. My lord,
There is a request for adjourning it for a day.
I am seeking for the moment just one simple interim protection.
Yes.
That the headmistress's room be sealed, so that, my lord, the show cause is, my lord, absence of mechanism to distribute sanitary napkins to students. There's no provision for that. Yet we have a dispenser arranged from an NGO that classes are dirty. Now I apprehend that misappropriation of funds will be incorporated.
if they get to the issuance of the charge sheet, my lord is there.
No,
But the-
misappropriation of fund comes later on.
Yes, the
Right, immediate interim relief.
is the headmistress's room be
Are you ready with the matter today?
No, my lord, I have not.
Brief has not been received.
received on 13th by the client, president of the board? They take their time.
My lord, I have.
Let the headmistress's room be sealed because it contains the 4 almirahs, my lord, where the papers and the cash is there.
Cash is also there.
Ca-
Are you aware as to the amount of cash inside?
It's not
Not possible.
even for rupees 25 years ago, there was a dismissal order sustained by the Supreme.
So right now you cannot say how much is there.
I have taken instruction, it will be maybe about 10,000 rupees.
All right.
But let it be sealed till my lord hears out the application. Well,
Okay.
not hears out, but at least the prayers for the other interim reliefs.
And who will be responsible for sealing it?
I responded number 5.
The police has made a party?
Yes, yes. I see Rajarhat. It was at her instance, I think, my lord, that she was rescued. I have a video, my lord. It will send shivers down one's spine. The way a woman is harassed by, they are taken to be guardians, but they are actually rank outsiders.
All right.
But I fear that,
Very well.
yes, that only limited
All
protection.
right. When do we post the matter for hearing?
Whenever it is convenient.
Be getting the brief by today evening, your lordship. Thereafter, any day, your lordship, please. Your lordship remembers, my lord, this petitioner came before your lordship.
I have placed the orders.
26th is a long way. Today we are on 17th. Right. I was thinking of Friday, if in the meantime you can. But then the interim relief which the petitioner is seeking for sealing of the Almara, that has to be...
Well, that is upon the DI, between the DI and the.
no, not the DI.
The
Not the
state
DI.
is
Because,
represented. State is
because if his allegation is that in the meantime the Almira will be opened and
there are some loose
evidence
vouchers.
may be tampered, then that will be a problem.
So, I mean, that,
Acha.
that respect, your lordship, DI is the, first they seek help from the DI, your lordship. So,
DI has acted at my, contrary to my interest, my lord,
Acha, the
flouting orders of the board also.
the petitioner is aggrieved by
he
the
has been suspended also.
That is not
aggrieved
challenge.
by the order of suspension passed by the president, ad hoc committee, West Bengal Board of Secondary Education
Lordship. Lordship, may I-
on 15th of January 2026.
As per the instruction today, I got the brief. I never consult with the school
Client.
authority. But they already given the notice to the headmistress to hand over the charge. But still today, the room is under lock and key, and the key with the custody of the headmistress.
Absolutely. But one thing, that is the last annexure.
ঠিক আছে? Learned advocate for the petitioner submits that she was serving as the headmistress of this school. Stop. There are certain important and valuable documents and cash inside the almirah.
There are 4 almirahs.
Inside the almirahs, which are kept inside the headmistress's room. Headmistress has a separate room.
Yes, the chamber of the headmistress. Yes,
So there is a
separate-
separate room where
Yes.
there is a provision
That
for
room
lock and,
itself is locked and the almirahs are also locked.
and you have the keys.
I have the keys.
Acha. Inside the headmistress's room. Stop. The petitioner has put a padlock on the said room. Prayer has been made to direct the inspector in charge of the local police station
Rajarhat.
to seal the room prior to hearing of the instant writ petition. Not prior to, till hearing of the writ petition.
No.
ঠিক আছে?
Transfer cancel.
Learned advocate representing the state and the board seeks time to revert with instruction. Stop. Paragraph. Learned advocate representing the school. Did you file your wakalatnama? School?
No, today I just got call number.
Please file your wakalatnama. File it. The school submits upon instruction that despite request being made by the president of the managing committee of the school, the petitioner has deliberately not handed over the keys of the headmistress's room.
That letter is annexed. The time given to me for that has not expired. It's dated 11th February and I was given
7 days time.
That is the other ground for urgency.
All right. On a perusal of the notice issued by the school to the petitioner for handing over the
last page
documents to hand over the charge of headmistress, it appears that 7 working days time was allowed to the petitioner. Stop. The said time period is yet to expire. Stop. Paragraph. As the petitioner apprehends that evidences may be tampered if the lock of the headmistress's room is opened in the absence of the petitioner, accordingly, the court thinks it fit to direct the inspector in charge, Rajarhat Police Station, to seal the headmistress's room for the time being. Stop. Learned advocate for the petitioner is directed to communicate this order to the respondent number 5.
The learned state advocate may also do that.
Is also there. Is also there. The aforesaid order shall also be communicated by the learned advocate representing the state respondents.
Let it be videographed or photographed.
Presence of the DI. Yes. DI.
And also in presence of the school authority.
Yes.
Then in my representative of the petitioners.
The respondent number 5. In that case, I can fix up a date when the sealing can be done.
It has to be done today.
Then will you be able to go there? Do you stay there?
Somebody younger than me.
Me in the sense the petitioner. I am not saying the council.
Petitioner cannot go. Petitioner is facing a threat to her life over there. I can show
Any
my
of
lord
your
that
representative, any of your representative will be there?
Yes.
The sealing by the inspector in charge shall be done within a period of 24 hours from the date, from date in the presence of the representative of the district inspector of schools, the representative of the school managing committee and the representative of the petitioner. Stop. The entire process of sealing of the headmistress's room shall be videographed and videographed by the police and be placed before this court as and when called for. Stop. It will also be open for the petitioner and the representative of the school to videograph the process of sealing. Released. Friday I keep it?
I'm no problem.
20th. 20 तारीख. Monday? All right, 23rd.
One thing, Malak.
Yes, please.
I need leave to correct the presentation form.
What has happened?
It was the learned government pleader who graciously, my lord, accepted a notice with the corrected date. That is why I can address my
corrected date?
It's 18th over there.
18th of February.
Today is 17th.
It was March 17th, then it
Yeah,
was.
at their insistence of the, they act very mechanically.
It is there. It was
No,
kept that
forwarding
way.
letter at 17.
Acha. Leave is granted to the learned advocate on record of the petitioner to correct the
তারপরে তো মানে জিপি নিলেন
presentation form.
and affidavit signing.
Leave is also granted the advocate of the HRita ফেরত যাবে school
Advance copy লেখা
to file the wakalatnama in the department. Can you file it today in the course of the day, wakalatnama? In the course of the day. Affidavit of service filed in court is taken on record. This order will be put up in the server so that you can communicate. And how will your representative get the information? I do not know.
Representative would be some junior of mine, nobody else.
It will be done, but then you have the on record's phone number. Please coordinate so that somebody from this petitioner's side is present.
At least the learned advocates are there, my lord. Let whoever advocate of mine goes, well, let his safety be ensured.
Safety be ensured.
Let Mrs. Koili Bhattacharya represent.
Ms. Bhattacharya is not going over there.
Obliged.
On item number 9, I am appearing for the petition. But this petition is preferred due to non-payment of area salary for the period of 11/9/12 to 28 February 2018. Lordship may remember yesterday the same application was preferred and it was make a not today due to non-presence of the state advocates. Here, my lord, my joining is page number 14. At page number 14 on 11/9/2012, and subsequently, my lord, I make my representations before the DI and
1 minute. Joining is 12.
12.
And where is your appointment letter?
Appointment is, my lord, page number 13, my lord.
By
At
the
page number
school.
13, 3/9/12, dated
All right.
3/9/12.
And 15 is
And my lord,
2018.
15 is my approval.
Approval is 2018. You did not get salary from
From the
12
period
to
of
18.
12 to 18, my lord. Area salary.
And when did you make the representation?
The representation is 2024.
24.
By the school itself at page
The matter was taken up yesterday.
yesterday, my lord, 6 similar matters.
Right. Has the order been put up in the server? Not
Order
yet.
is not uploaded, my lord, still till
Not yet.
not yet. But my lord allowed the prayer and in accordance with law directed DI to disburse this
Without any interest, if I am not wrong.
without any interest.
Can you give me the case number?
Yes, please. একটু কেস নাম্বারটা দিদি আমি বলে দিচ্ছি
Then the same order can be passed.
26890 of 25 একটু নামটা লিখে দে কস্টেটটা লিখে দে
All right.
Got-
Same order will be passed.
same one but make it kindly be a time frame because yes previous order I think there is no time frame
No time frame,
no
There was
just time frame just time frame
a time frame, Your Lordship.
isn't it?
Yes, it is. 12 weeks. 12 weeks, Your Lordship.
6 months times in this matter.
6 months only. Why? Why you want 6 months?
এটা আগের ম্যাটার
Fund, my lord, kindly para
কতকাল
then assume that the area claim will be weighted by the joint director of accounts who section and will be placed before the Commission of the School Education West Bengal to allot the fund. As soon as fund will be received from the Commissioner of School Education, it will immediately be disbursed in favor of the petitioner.
Yes, where is the 6 months coming from?
For shortages of
Clear,
fund,
similar
my lord.
product.
Shortages of fund, my lord.
একটু দেখে নেবেন তো কালকে যে অর্ডারটা হয়েছে সেই অর্ডারটাই হ্যাঁ Same order will be passed. Disposed.
Not affidavit of service may kindly be kept on record.
Take full.
Kindly consider the earlier order passed by my lord.
Deficit court fees.
My lord,
Good. Receipt.
receipt my lord, I have submit.
Has the report by the commission be prepared?
My lord, what has happened is that 69 petitioners are involved.
Ah.
I have not been able to get all the data to deal with the report. I had a discussion with the chairman because they have submitted one representation. One is annexed to the writ petition. One recent one has also been given to the commission.
And is it in respect of all?
Yes.
Joint representation?
Yes. So instead of
Representation.
yes,
Considered.
instead of
Lordship kindly consider one thing, my lord, at that relevant time, when my lord we became, my lord, we have
Date of filing the application, they were within age, and on the
Yes.
date of verification, they have been found to be overage.
yes, so that we will consider, and for each candidate we will take a decision and intimate.
Where is the representation?
my lord,
Last
at
the
age
last annexure.
266.
Achha. The petitioners participated in the first SLST 2016 recruitment process for appointment of upper primary school teacher. They were eligible on the date of filing the application for recruitment, but on the date of verification of their credentials, they have been found to be overaged. Stop.
That is their submission to that.
What is your submission?
We will verify each candidate and
The petitioners have submitted a representation before the commission
yes.
to provide appointment to them by taking into consideration of their age on the date of filing the application. Stop. A representation from the petitioners is pending consideration before the commission. Stop. The paragraph, the instant writ petition has been filed by 69 petitioners. Stop. The commission intends to consider the case of each of the petitioners individually. Stop. Paragraph. In view of the above, the instant writ petition stands disposed of by directing
The respond number 9, my lord, I think.
chairman of the commission or the secretary.
Secretary. That is the
Secretary.
secretary.
The Secretary of the West Bengal Central School Service Commission to take a decision on the petitioner's prayer in accordance with the prevailing rules at the earliest, but positively within a period of 8 weeks will be all right.
My lord, 8 weeks.
8 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to each of the petitioners separately.
Yes.
Stop. Learned advocate for the petitioner is directed to forward a copy of the representation to the aforesaid respondent at the time of communicating the order of the court. Hearing is not required.
No.
Because you can verify the
Yes,
documents.
it is purely based on the records.
You have your own document.
My lord. My lord, so far age relaxation is concerned, lordship kindly make. And
Why relaxation? What the law says, you have to see that.
lordship kindly, my lord.
No, they have not taken a decision now. So I will not say anything about relaxation. Whatever is the order they will pass. If you are aggrieved, you can come. Because if I say relax age, then how will they consider? They will not be in a position to consider only. Dispose holo to?
Lord, if we come again, my lord, by this time, lord, our age, my lord, will be open
ঠিক আছে।
for retirement also.
Deficit court fee already paid.
Disposed. Receipt showing payment of
My lord,
deficit court fees
that
credited
deficit
with the
court fee
records.
Yes.
Next matter, item 11 is taken up. 11 have we got, sir?
11.
My lord, item 11, I'm for the commission.
I appear for the intervener, Your Lordship.
It is a 2017 matter.
The advocate on record is engaged in courtroom number 33. Kindly give short counsel.
Advocate in record is engaged. Where is the arguing counsel?
He is only doing
I can see two names. What is your name?
Saurav Gupta.
Saurav Gupta. Where is Siddhartha Sarkar and Akash Ghosh?
Courtroom number 33.
Both.
Yes, sir.
Both cannot argue at the same time.
Your Lordship, Siddharth Sarkar is actually engaged.
Yes. Where is he? What is the matter? 2017 matter.
My
Does
lord,
anything survive?
Yes,
Not today.
my lord, let it be on 2nd of March, because another matter which appeared with this
Similar?
matter, whether
Uh-huh.
the factually it is similar or not, that I'm not, I have not managed to check, but they came up together last week, and the other matter was fixed on 2nd of March. So let
Alright,
this
an
also,
accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Released on 2nd March.
Grateful. Lordship will kindly allow me to make one submission. There is an order impugned is an order passed by the West Bengal School Service Commission. After that, there was another report, there was another hearing, which is not mentioned in the writ petition. If your Lordship kindly, the commission kindly comes with that report, that will be necessary for adjudication in this matter.
Let the commission's counsel is here.
Okay,
They'll take
for a
this.
But earlier regulation, there is a direction upon the state to take instruction on the matter. Malata, I could kindly grant me 2 days time, not day after tomorrow. Let it be day after tomorrow. Only 2 days time.
On the prayer of the learned advocate representing the state respondents, seeking extension of time to obtain instruction in the matter, release the same 24th of February, next Wednesday.
But could I just get a copy of the instruction or written report if you're after he files?
Malad, if I get the written instruction, I will supply.
Great.
I appear for the petitioner, my lord. The commission has served us with a copy of a report. We want to take an exception to it. It was served on the 5th of February. I need some more time to file my exception, my lord.
Where is the report, please? Report by the commission. Filed in court today is taken on record. Stop. Learned advocate for the petitioner seeks time to file exception to the same. How long?
As your lordship, please.
You say how long you will take. What is the matter about?
My lord, 2 weeks.
What is the matter about?
Lordship, the matter is about the petitioner wanted to participate in the first SLST examination, my lord. While uploading his documents, application form, he was not allowed to do so due to some technical glitches.
Stand of the commission is that no technical glitches was there.
Stand of the commission is that due to my fault, so I could not really fill it up in a proper manner. My application form.
All right. Released on 6th of March 2026. Reply may be prepared and circulated prior to the adjourned date.
Exception.
Reply have an exception.
Yes,
next.
Let me establish.
I am for the state in this matter, Lordship.
All right.
14 for the petitioner.
I'm led by Mr. Roy, second by SSS.
There was a
13 at it.
30.
40.
About the school authority.
Is the state represented?
No, my lord, the lordship last occasion, please direct me to serve a notice to
Who is appearing?
Lord, the Prashant Kumar Giri, Lord, with my lord, the Tapos Chatterjee. I am the
Ready with instructions? Yes, what is the challenge?
Here, my lord, the challenge, the petitioner, my lord, the teacher in a special school. My lord, the petitioner applied for transfer through Utsoshi portal. My lord, there is no, my lord, the provision to, my lord, to get facility from Utsoshi portal. However, my lord, the petitioner's application was not considered. The petitioner made an, my lord, the file a writ petition pursuant to order passed by this honorable court. My lord, the director of school education, my lord, passed a rigid order. My lord says that there is no provision in respect of, my lord, the Utsoshi portal to, my lord, facilitate in respect of special rules. My lord, my humble submission only where the Ramakrishna mission, my lord, the teachers has been get, my lord, facility by, my lord, the order passed by the principal secretary, additional secretary, my lord, page 33. My lord, let my lord.
You first tell me
My lord.
that the post in which you are serving,
my lord,
is transferable.
No, because of that facility is not there.
Transfer facility is not there.
It's a institution governed by a special rule.
Yes.
They are not appointed through recommendation of School Service Commission.
Right.
They are appointed by us. So
Yes.
there is no question of having any branch.
Right.
No, there
Transfer
is
is
school.
Transfer is not permissible.
No, there is a other school.
How can the transfer be given?
Well, because of there is a other school in respect of, well, run by special in near of the, well, the petitioners. Well,
maybe, but then who is going to give you appointment over there?
Well, only, well, my humble son, the because of all facility, financial facility given by the state. Only, my lord, that this, my lord, the issue is, my lord, taken into consideration by the state authority, where the, my lord, the Ramakrishna mission also, my lord, the appointing authority is, my lord, the
show me the
my lord,
Ramakrishna
page
mission.
73. Page 73, I have annexed. My lord, this order also passed in terms of an honorable court order. Only, my lord, my prayer, my lord, the authority will take a decision only. Same qualification, same scale of pay, everything is, well, the controlled by the state. Only for appointing authority is, well, different.
Did the School Service Commission?
Appointing authority special rules by governing body.
My lord, the point is 73.
Yes.
But now, therefore, kindly have a look. Now, therefore, the governor is hereby pleased to order that the teachers and non-teaching staff who are working in the school under Ramakrishna Mission, Belur Math, on the basis of recommendation of the School Service Commission prior to 6 September 2012. That was the guiding factor. So they are the teachers who are appointed through recommendation of School Service Commission. They got this.
Yes, yes.
The case is completely different.
How are you covered by the School Service Commission?
No, I am not the appointing or recommended by the School Service Commission.
Then how can you seek
My
the
humble submission, the appointing authority Ramakrishna Mission, before 12, my lord, the School Service Commission was appointed, but subsequently it has not been recommended by virtue of this honorable court's order. Therefore, my lord, the school authority, well, the state authority has, my lord, taken a consideration because of the schools, the Utsoshi portal has been already facilitated to the School Service Commission teachers who has recommended. But my humble submission, if there is no scope in respect of special runs for transfer, if the authority has given the financial benefit, scale of pay, everything, so let the authority will consider whether the special run school also be taken into consideration for transfer. Only prayer for this respect. Otherwise, my lord, I have no scope because of, admittedly, I have no appointee School Service Commission. If that, my lord, the facility is
How it is permissible, madam?
A new rule has to be framed.
He has appointed by the managing committee.
That is
And
the
approval is
thing.
given by the district inspector of schools.
Right.
My lord,
Commission does not come in anyway.
anyway, and where he will be posted. He
because of
pursuing his duties in a school run by the Arya Samaj,
I'm not denying that.
guided by the 1973 rules.
I'm
There
not
are two
denying.
special
How?
schools.
Where will you be posted?
Because of, my lord, the special school run.
And
School
who is going to take a call in this matter?
well, that's why, my lord, the control over by the approval authorities DI. And, my lord, the director.
Approval of appointment is something different.
Yes, my lord.
Once you are appointed, your service gets approved.
My lord.
The school is an aided school. That is all right. But then the scope of transfer,
My lord,
I don't know, because here Ramakrishna Mission, it has been applied prior to
yes, absolutely.
12.
Yes, my lord. I am admitting that.
After that, there is nothing. So
Because
how
after-
can you get the benefit?
So, my lord, let the authority, my lord, take a decision and to issue a frame, a rule. So, my lord, the
He wants
only.
framing of a new rule.
So, my
It's to be done by
lord,
the court.
Lord, because of only this is only.
How can court frame rules?
No, I'm
That is fair.
I'm
What
direct.
is fair is to direct the
Yes.
authority to frame rules.
To only
That
to get
is
facility.
the
Only
prayer.
consider. To consider and, my lord, take a decision to, my lord, frame if there is, my lord, scope to, my lord, get benefits.
See, the district inspector of schools report is here and it is not in favor of the petitioner.
Absolutely, my lord. I'm
So,
only, my lord,
how
direct-
can
my lord, only kindly direct to the, my lord, principal secretary to take a decision, and if there is a scope to facilitate, my lord, to the special learn school, then, my lord, they issue a notification. So, my lord, this kind of teachers maybe, my lord, get this.
Is this a public interest litigation?
I am the
I'm
the
next,
person.
but next issue would be, but let us accept that he has been allowed to be transferred by the authority. Let us accept. Then there would be a vacancy in our institution. We are not going to get anybody from the School Service Commission. A fresh
the school service commission, you have to start a fresh
selection process. Why should this
the
burden?
school take this burden?
In case of approval of
Or
Every day someone will come. This is my difficulty. Allow me to be transferred. Next proceeding. Next
another prayer, my lord.
This cannot be.
Another prayer, my lord. If there are other school who, my lord, run by, my lord, the special learn, if the district inspector of school or, my lord, the secretary to, my lord, that the facility to transfer from one school to another school in respect of, my lord, special learn school, that also can be done. Then there is no, my lord, the scope of, my lord, the.
See, this is going to increase the burden of the DI. The rules does not permit. So,
yes, I'm admitting that. But
in
there is,
one of the matters, the Commissioner of School Education has refused.
Yes, ma'am.
Same special school, special rules. The commission is not here.
This is
not here. I'm talking of separate matter. It has been refused, saying that there is no rule and it cannot be done. So what is the use of reverting this to the
because of
authority?
lady teacher has, my lord, the suffering because of, my lord, one.
But if your service rules doesn't provide, then nothing can be done. You cannot ask the authority to frame a rule for your own purpose.
My lord, for consider if there is a possibility to, my lord, get that facility.
That cannot
because
be
of, my
done.
lord, everything controlled by state. My lord, fund allotted by state. My lord, the scale of
No,
pay
no,
is
that I can understand.
only
but
for
then-
the change of, my lord, the appointing authority. My lord, the person to be suffer, let the, my lord, authority be.
Why suffering? This is your service condition. You knew on the day of your appointment that you did not have any scope for a transfer. You accepted the job.
Absolutely, I'm not.
Then
because of this Utsosri portal and transfer has
portal
been.
is different. It is for a different category
ma'am.
of teachers.
My lord,
Why you do not fit in? You participate in the recruitment process by the
so my
commission.
age is, my lord,
Then
my lord, age is,
Even tense is not applicable prior to 1997.
my lord, my age is
Where
45.
I can understand that the candidate does not fit in anywhere. And if your service condition doesn't provide, It is not for the court to direct the authority to frame a rule. This possibly cannot be done.
If there is, my lord, because our state is, my lord, controlling everything, my lord.
No, show me, bring judgments where the court can pass similar orders directing the authority to frame rules which is not there in your service condition. You bring, then I'll see. Alarjan, please come. The petitioner seeks transfer. Stop. The service condition of the petitioner does not provide for transfer. Stop. The petitioner prays for a direction upon the principal secretary of the state to frame rules for benefit of the teachers run by special rules so that they may avail the transfer facility. Stop. The court is not convinced with the submission of the petitioner. Stop. Learned advocate for the petitioner may revert with judicial precedents in his favor. When to keep? 2nd March?
2nd March.
2nd March. Instruction forwarded by the District Inspector of Schools, Secondary Education, Paschim Medinipur. Signed on 17th of July 2025. Filed in court today. Be retained with the records.
Grateful. Grateful.
My lord, in this matter, Mr. Torun Kumar Das will appear. Kindly make short pass over. My lord, only no.
Pass over.
আমি স্টেটের হয়ে আছি হ্যাঁ last one, you got directed.
State, you.
My lord, I am for the state.
You were directed to revert.
Yes, my lord, I am ready with the report.
Whether there is any requirement of continuing the petitioner as a nominee of the department. What is your instruction?
My lord, the instruction says, my lord, the concerned person, he was nominated by the deputy secretary to act as a president in the year 2023. So as per Rule 10 of 1972 rules, the term expired, that is the instruction of the Deputy Secretary, on 1st of February 2026. So my lord, his nomination, my lord, further continuation may not be required. And your lordship's second query was why the District Inspector of Schools, he has not initiated steps for formation of a new managing committee as per Rule 10, since it has expired after expiry of 3 years. Now, my lord, to that aspect, my lord, my instruction is this. There is, my lord, a government memo, my lord, of 2019. My lord, lordship may kindly peruse annexure E of the instruction. No. My lord, on the basis of this, my lord, till formation of new managing committee.
The person will continue.
My lord,
the earlier managing committee will continue. Yes, this is all right. No, but then that is different.
My lord.
The fact that the managing committee period expired and the old one will continue with this is not the proper manner in which the managing committee should function, right? Why are steps not being taken for constitution?
Subject to your lordship's approval, my lordship may kindly direct the DI to initiate appropriate steps for formation of the new managing committee. My lord,
that should be done.
Yes, the
only showing this, the old one will continue. It will continue for eternity.
I understand. So, lordship may kindly, my lord, direct the District Inspector of Schools to, my lord, initiate appropriate, my lord, steps for formation of the new managing committee.
And tell me one thing: does these nominees receive any fund from the state? Because the claim of the petitioner arose on 2nd of February 23, when he was appointed as a nominee. He was not able to function.
No, my lord,
does he lose anything?
No, my lord, subject to correction, only one thing. This is not under challenge. So, my lord, the erstwhile, this is also part of my instruction. The erstwhile president, my lord, of the managing committee, my lord, he tendered his resignation on, my lord, on 9th of December 2025. This is
That
the,
means,
so my lord, I understand, my lord, the specific query of your lordship. Is there any financial benefit he is losing?
Yes.
My lord, to that aspect, my lord, I have to take it up, but my lord,
because
but
that
my lord, there is another part. Why he is not allowed to function? Probably that is indicated on the last occasion.
Yes.
Your lordship, yes. Right. My lord, there is a allegation of, yes. Yes, no, my lord. This is the part of the instruction that is probably not correct submission. Lordship kindly sees annexure F of the instruction which I have handed over. That is pending. So, my lord, this specific submission by the writ petitioner subject to correction is not correct. My lord, the proceeding, this is the information. This is in respect of GR number 7184 of 2014. The next date is 6th of July 2026. So, my lord, the proceedings, my lord, annexure F. My lord, may I? F. Handwritten document. My lord. Lordship will find the date, my lord, at the right hand column, bottom.
718.
Yes, yes.
Next date is 6th of July.
My lord,
26.
that is pending.
Pending in the sense is an application for restoration file because it was dismissed for default. It mentions on 8th of February 2026.
No, my lord, that is the writ petition. My lord, this is something else. This is a proceeding.
Oh, achha, writ petition is dismissed.
Yes.
And the proceeding has ended. This is not the, this is not correct.
That is not that is the that is reflected from the information slip. That part of the submission is not correct, man. তোমাকে দিয়েছে একটা ইনস্ট্রাকশন
Please come.
আচ্ছা এইটা হচ্ছে
Learned advocate for the petitioner seeks accommodation. Stop. Instruction by the District Inspector of Schools, Secondary Education, Barakpur. Dated 10th February 2026.
Right.
Filed in court. Be written with the records. Stop.
Also, my lord, the instruction by the Deputy Secretary. This is also maybe written since there is direction from your lordship, my lord. Which?
Report by the Deputy Secretary, School Education Department, Secondary Branch. Signed on 16th of February 2026. Filed in court, be also written with the records. Stop. Let a copy of the instruction be handed over to the copy of the instructions have been forwarded to the learned advocate representing the petitioner. Stop. Released on 2nd March. Learned advocate for the parties shall make necessary submission on the adjourned date.
My lord, 2nd March. My lord, can it be on 6th of March?
Friday you want? Why?
My lord,
9th of March.
Wait.
Item 61 for the petitioner lordship made by Mr. Tito Son, please engage before the court room number 11.
Well, let it be not today, my lord. Lordship last occasion directed the steps to collect the information regarding VRS. Mr. Chattopadhyay has information regarding that. He has not joined today, my lord. He will be there from tomorrow. But we'll kindly make it then not today. Any oral instruction as to whether voluntary return?
Yes, my lord.
Yes, there is a provision.
I have the circulars.
But by this application here, she has to apply. Yes, obviously.
Before the board, we have the circulars.
You have the circular. Let it be not check up the circular so that if fresh application is required, you can make not today. Deeply obliged. Thank you.
For respond number 9 and 10 school.
For the petitioner, my lord, the report which was directed to be filed has been filing, my lord. I have already received a copy of the same. My lord, I 2 weeks time to file exception to the reports they are filing.
This is my report, my lord. Schools.
You are for the school?
School and the
present PIC, and there was a direction, the second last paragraph.
Achha, report filed by the.
Lord, I am for the state. The Lordship also directed me to file a report.
Is it ready?
It is ready.
Please
Lord,
give.
only one problem is this, my lord. I have annexed everything, but one notification relating to my lord qualification to be appointed as assistant headmaster, that was left out. First page was there, others part only. I have handed over, my lord.
All right. The report by the state and the school filed in court be taken on record. You got both the reports?
Yes, ma'am.
All right. Learned advocate for the petitioner seeks time to file exception to the same.
কোনটা মিস হয়েছে বুঝলেন না? আমি তো তোর তুই দিয়েছিস ম্যাডাম, তোরই ওটা তুই রেফার করেছিস ওটা। এই দেখ এইটাই যে 2002
March.
17. এটা তো আমি অ্যাটাচ করি। আমরা 8 করে দিই।
Exception may be prepared and circulated by 11th of March.
কিভাবে সার্কুলেট করেছি আমার দিতে? 17th of March.
কোথায় তুই এটা অ্যাটাচ করেছিস? বোকা কথা বলছিস।
আচ্ছা আমার একটু আমি করে দিয়ে দিচ্ছি।
এই যে এটা নিন, এই যে
এসো তোমারই সব
89 for the lord of petitioner. Here, Lord, the petitioner has been placed to an English medium school, although Lord, he is a teacher of the Bengali medium school, and the district inspector of the school issued such order. My contention was that the district inspector of the school has no such power.
Why did nobody appear yesterday? The matter was called on.
It was the necessary party.
My lord, for personal inconvenience, I had to go to the hospital.
You could have kept somebody here.
My
You
lord,
could have intimated your learned senior friend.
my lord,
This was not done.
my lord, due to the emergency, I had to leave, my lord, to the hospital, my lord.
And your learned senior friend is waiting from the morning.
My lord, when we spoke, I intimated that.
Achha. What is your instruction?
My lord,
Show me your written instruction.
my lord, first board is answering respondent here, my lord. My lord, before that, my lord, may I indicate page number 14, my lord, the prayer portion, my lord. My lord, the petitioner has challenged by order of November 25, my lord.
Virodinto, you've handed over 3 copies. Yes.
My lord, at page number 14, my lord, the main prayer of the petitioner is challenging the memo dated November 25, my lord. My lord, the memo dated November 25, 2025, my lord, that has been withdrawn and cancelled, my lord. And my lord, the main bone of contention of the petitioner is at page number 5 and 6, my lord, that the said memo has not been issued by the district inspector or not 24 Parganas or the district inspector Barakpur, my lord, as the case may be, and that has been, my lord, withdrawn and cancelled, my lord. My lord, so far as the subsequent
Which one is cancelled? Please show.
my
21.
21.
The 25th of November 2025 is issued by the district inspector of the school, but not 24 Parganas.
Yes. Temporary service placement of teachers. Petitioner is Chandra Viswas.
This has been, I am telling your lordship, this has been withdrawn on 27th, or similar order has been issued that I have challenged by filing the supplementary affidavit. And my learned friend junior was there at the last occasion. I handed over to her. But today is now the subject amount of challenge is 27 November 2025.
My lord,
The
from
difference between
pleading, sorry to interject. My lord, from the pleading, it does not appear that they are challenging. Even they have filed a supplementary affidavit, but from the pleading, it does not appear that they.
My bone of contention of this, Lord, the district inspector of school has no authority to issue the order of placement. Their contention by filing, Lord, the report to the learned, it is not report, not the instruction to the learned advocate. Lord, one copy has handed over to me the last occasion, that the proposal has been sent by the district inspector of school to the commissioner of school direction, and the commissioner of school direction approves such proposal. submission before your lordship is that whether the district inspector of school has any authority to make any proposal for placement of the service of a Bengali medium school teacher to an English medium school first. Whether the necessity of the such teacher has been examined. Third, Lord, the medium of instruction has been considered in this case or not. Your lordship, kindly come to my writ petition as page 29A. This is the necessity, 29A. This is the order of the district inspector of school dated 13 September 2022. In serial number 7, Suparna Goswami, assistant teacher, work education, she has been placed to that particular English medium school.
1 minute. See, you have placed the petitioner in a school where there is requirement of a teacher. Why don't you place her in a Bengali medium school?
My lord,
He is not acquainted with the language.
my lord, she is a teacher of work education, my lord.
And so she is not required to speak in English. In English medium school, you speak in Bengali in work education classes. Do you?
My lord, there is no student in that school right now.
You place her in any other Bengali medium school.
My lord, I will come back with the instructions on that.
This is the name of the 4 school, Lord, nearby. It is, I confirm it from the Lord school.
Peruse
that
instruction forwarded by the District Inspector of Schools, Secondary Education, Barakpur. Signed on 9th of February 2026. Stop. It appears therefrom that the petitioner has placed in an English medium school on temporary basis to manage the crisis of teacher in work education. Stop. Paragraph. Specific case of the petitioner is that she is not acquainted with the English language, not acquainted, no. She is not fluent in English language, and it is not possible for her to manage the students of English medium school. Stop. Learned advocate for the petitioner has produced a list of 4 schools where there is vacancy. School Bengali medium schools where there is vacancy in the work education class, work education subject. The
My lord, the memo dated November 27th has not been challenged. Let him make a representation before the authority with the this prayer, my lord. We will consider and take appropriate steps, my lord.
Consider in terms of the court's order.
Lord, there is no scope for, I have already been released. Kindly consider this aspect of the matter.
The District Inspector of Schools is directed to apply mind and to take a decision considering the difficulty faced by a Bengali medium student to handle classes in English medium schools. Stop. The subject of the petitioner may be work education.
She is a graduate.
But she is supposed to speak in English in an English medium school. Stop. The petitioner has expressed her inability to speak fluently in English language. Stop. The DI ought to consider that the petitioner was initially appointed in a Bengali medium school, and if at all the petitioner's service is required to be transferred, the petitioner is required to be transferred in any other school, comma, then the school should necessarily be a Bengali medium school. Stop. Practically, it is very difficult for a student of the Bengali medium school to teach. It is not practically, it may be difficult to teach in English medium school. Stop. The list of 4 schools handed over by the learned advocate for the petitioner is forwarded to the learned advocate representing the district inspector of schools for taking a decision in the matter. Release the matter for further consideration on.
Very short, because I am on.
My lord, may I indicate, my lord, these 4 schools or any other Bengali medium school, because
Yes, yes. I am not saying that you place her over here. In any other Bengali medium school with work education vacancy, you can post her.
It is nearby school, that's why, my lord, I am giving such list, my lord.
I
There is no other
understand.
purpose.
I understand.
My lord.
He also understands. You will not mention a school which is 200 kilometers away. You will mention a school which is 20 kilometers.
Yeah, my lord, issue such order in a different, my lord, altogether, my lord, her object and purpose is different. Was different.
2nd of March.
2 persons made as a party as DI. Yes, one number 4 and 5.
Yes.
In
The
person,
reason is this, my lord, when the first order, the implement.
DI is not the party. Page 2.
What you are saying?
Kindly see page
2, yes. Personally, I made them party because
Why?
at the relevant point, I'm explaining you before Lordship. Because when the 25th of Lord
not the party.
11, 25th November 2025 issued, that time, Lord, the DI of Barakpur was, Lord, on leave and with a leave to the out of station. But that time the issue, this order, impugn order issued, which is, Lord, at page 25 by P3, by the someone, some AI. He was not there. Then immediately he realized that this is wrong. That time charge was brought by district inspector of school, not 24th Parganas. I am,
You are under whose jurisdiction?
Barakpur.
Not 24
Barakpur.
Parganas.
Yes. No. Barakpur. Under the district inspector Barakpur. So you fail to understand my contention. Why I am party the 2 districts school. At the time of
Barakpur is different from North 24 Parganas.
It is Barakpur district.
my lord,
Education district
his
is different.
contention,
Education is different.
Different. Lord.
All right.
Lord,
my lord, his contention is not that the DI has made anything wrong. His
yes, absolutely. This is frivolous.
They
Lord, this is manufactured.
allow me.
District Inspector of School, Secondary Education.
His
Barakpur, Lord,
contention is that under the seal and signature of the DI, concerned DI, someone else has issued a notice.
Let you delete the name of Prantosh Maiti. Right?
Lord, why I have a lordship? Can you page 22? A lordship for a moment. For a moment, Lord. Why I am referring this by name?
In that case, you add District Inspector of Schools, Secondary Education, Barakpur, not 24 Parganas as party respondent. If you still want to continue with the others,
then your lordship, as your lordship.
leave is granted to the advocate on record of the petitioner to implead the District Inspector of Schools, Secondary Education, Barakpur, not 24 Parganas, as party respondent in the instant writ petition. Stop. The formality of serving a copy of the writ petition upon the added respondent stands dispensed with, as the state is already represented by the learned counsel.
Respondent number 4, Prantosh Maiti is at present he is the district inspector of the school.
You have to implead the post as a party, not the person concerned.
The reason behind is that
if you have separate reasons, the court will listen to that, but the DI has to be there. So you please add.
My lord.
19. This will be the last matter for the day.
Kindly leave me again. I have
19.
My lord, I am for the statement.
Lord, widower came before your lordship.
May I have
Yesterday, your lordship adjourned this matter. This is regarding
Yesterday it was adjourned.
Yes, madam.
Why?
My lord, senior was not represented.
Today is here.
Today is there, my lord.
Ah.
My lord, the widower came before your lordship regarding the claim of interest on the death gratuity, ma'am.
Well,
Lordship has directed to file a report, my lord. A copy দেওয়া যাবে?
I am handing over a copy to the magistrate. My lord, can you come to para 2, my lord, the date of application?
When was the application for
It was made, my lord.
terminal dues made?
That was not annexed.
That is not annexed, my lord. Then, my lord,
The DI has said you made it in only in July and it was released in November. Where is the delay? Please come.
my lord,
From the instruction forwarded by the District Inspector of Schools, Secondary Education, Howrah, dated 15th of January 2026. It appears that the petitioner applied for family pension both online and offline on 12th July 2024 and PPO was issued on 19th of November 2024. Stop. The paragraph there, the petitioner prayed for interest on account of delayed payment of the terminal dues of his wife, who died in harness on 30th May 2019. Stop. The petitioner has not annexed any document to show the date as to when the application for releasing the terminal dues was made. Stop. In the absence of any specific averment from the petitioner, comma, the instruction forwarded by the District Inspector of Schools upon verification of records has to be taken as true and proper. Stop. Next. The court is not convinced that there has been any delay in issuing the PPO in favor of the petitioner. Stop. The prayer for interest made by the petitioner cannot be allowed. Stop. The writ petition fails and is hereby dismissed.